and is sort of, dead beneath the police officers. Why is there not emergency medical aid provided at that point? So I thought the state was effective in cross-examining Dr. Fowler and punching holes in some of his theories and findings. So again, that was effective. And then today they would get this chance to bring in a rebuttal witness to go even further.
All right, Paul, thank you. Appreciate it. And again, we are waiting for court proceedings to resume. That could happen at any moment now. But for right now, let's check in with Fox 9's Leah Bino, who's also been monitoring the developments in court. And I'm curious as to some of your biggest takeaways yesterday, and also the viewers hearing from Maurice Hall, a friend of George Floyd's, but the jury didn't.
That's right. He officially invoked his Fifth Amendment right not to testify. So we saw for just a brief time him in the courtroom addressing that with Judge Cahill, and then Judge Cahill accepting that determination not to testify. But just expanding a little bit on what Paul Bloom was saying and what the jury members were left with yesterday afternoon to process overnight and recap a little bit. But Dr. David Fowler getting to the heart of this case is, what is the cause of death? Is it undetermined, as Dr. Fowler thinks it should be, or is it homicide, as the medical examiner has determined? The precise definition that Dr. Fowler says is that Mr. Floyd died of cardiac arrhythmia due to heart disease during the restraint, while the medical examiner maintains that he died of cardiopulmonary arrest as a result of the officer's restraint. So you can see a lot of medical information, again, being thrown at these jury members all day long yesterday. We have a little bit of sound that we'll play for you so that you have a taste of what they were hearing yesterday as far as the explanation from Dr. Fowler on what he believes the cause of death is.
Did you form, in your opinion, to a reasonable degree of medical certainty, what you thought was the principal cause of Mr. Floyd's death?
Yes.
And what is that?
Cardiac arrhythmia due to hypertensive atherosclerotic cardiovascular disease during restraint.
Now, in terms of the other contributing factors to Mr. Floyd's death, did you, as a part of your review, make other considerations to things that may have contributed?
Yes, I did.
I'd like to discuss with you carbon monoxide, or CO. Okay. You've reviewed all of the videos in the case, correct?
I did.
Did you pay attention to where Mr. Floyd's head was positioned relevant to the squad car?
Yes, I did.
Which way was his face, nose, mouth facing?
His face was facing towards the vehicle, towards the rear of the vehicle, and directly towards the area where you would expect the tailpipe or tailpipes of a vehicle to be.
And let me just ask you, are you suggesting that Mr. Floyd died from carbon monoxide poisoning?
Absolutely not, no. Not a full carbon monoxide poisoning, no.
Again, that was some of the discussion yesterday from Dr. David Fowler. Another moment that Paul alluded to that came up during the cross-examination, Jerry Blackwell basically asking this doctor if he thought the officers were negligent in failing to provide life-saving measures to Mr. Floyd once they realized that there was no pulse about 5 minutes into him being restrained. And this physician said, as a physician, I would agree. So that was sort of a pivotal moment that we heard during the cross-examination. We'll be looking to hear what they have to say today. We do know, BC, that there were some reports from the pool reporter in the courtroom yesterday, that there were some notes from that reporter saying some of these jury members are kind of picking at their nails, not taking quite as many notes. So that kind of opens up the questions of, is there some testimony fatigue happening here? This is what, since a week or so now, we've been hearing nothing but medical testimony that is a lot for these jury members to take in. So you kind of wonder where they are at this point.
Mm-hmm. All right, Leah Bino reporting for us. Thank you, Leah. So now we want to go to trial attorney Mike Bryant with law firm Bradshaw and Bryant for some legal analysis. Good morning, Mike.
Good morning.
So yesterday, Dr. Fowler was the sole witness called up by the defense, and he had a lot to say. What did you make of his testimony?
Well, it was interesting testimony because it bordered on some very important things for the prosecution, but at the same time, it was broad enough and it went to the issues. It went to two issues. One, it broadened the reason for his death, and that's the defense's argument that there are other possibilities out there. And they don't have to prove anything. They don't have to prove it was something else. They just have to prove that they have to have the questions out there so jurors can conclude that they have an open question as to what the cause of the death was. That's how they get the acquittal. But alternatively, the other issue about it is the way he testified was it goes to the question that we had the day before that we've had with past experts is the use of force. Did what the defendant, were the actions of the defendant above and beyond what a reasonable police officer would do? And that's the two parts that the defense is trying to put a spotlight on to say there's still questions about these things.
And at some point, especially primarily during the cross-examination by the prosecution, Dr. Fowler seemed to backtrack some of his statements. What did you make of that?
Well, it was an interesting back and forth. The prosecution, both attorneys were incredibly prepared. When you see the exchanges that took place, I mean, we had one photo followed by another photo. We had a report followed by another report followed by another report. So we had all sorts of back and forth as far as testimony they gave, and then questions about that. There were points when he seemed to have some problems with some of the answers, but on redirect, the defense came back and tried to fix as many of those as possible.
And what do you think are the chances that the jury will hear from Derek Chauvin?
That's an interesting question. The timing is interesting because the last witness they hear probably today will be the last witness they hear before closings on Monday. So the jury's going to go home with the last witness. Now, it sounds like from Paul's earlier report, it sounds like for sure there's going to be a rebuttal witness. From yesterday, there was still a question about whether there'd be a rebuttal witness if they could show that there was something that was undisclosed in the report by the testimony of the medical examiner. Sounds like that may have been concluded that there will be a rebuttal witness. If that's the case, then the last witness is going to be that rebuttal witness, which is another doctor. And, the defense has to decide whether or not there's something that they think is very important the defendant wants to say. The defendant himself may decide, because of the charges against me, I really think I need to say certain things. Or they may decide based upon the timing, since he's not going to be the last witness, he doesn't have to testify, just like we saw with the passenger. They don't have to testify if there's pending charges, or they don't have to testify against themselves under the U.S. Constitution. He may decide not to do that.
And do you think that it could help or hurt Chauvin to do so, to testify?
There are things that could be used against him if he testifies. They can get into the discussions he had with his superiors right after this happened. There's some questions about the police report that was filled out by them. So there are issues out there. Originally I thought there were some they needed to get some of the things that were said at the scene out, and he was the only witness that could do that for him. Now they've been able, through the videotapes and through the use of experts and the questions they've asked, to get those things out. So I don't think he's a mandatory witness. There's dangers with him testifying, but he's been very active in this trial. He's taken lots of notes. He seems real active in his defense. So I'm sure they're going to make what they think is the best overall decision based upon what their strategy is. And their strategy is that he died for other reasons, and what the officer did was the best he could under the circumstances.
As Leah Bino just mentioned, we got a hold of the pool reporter notes from yesterday, and just basically kind of describing what they're seeing from the jurors, kind of seeming unattentive, not interested. Is it best not to look too much into how they are reacting in court?
Well, you never know what exactly they're thinking. You don't know what they're writing. They can be looking like they're taking extensive notes and they're doodling, or they could be hearing every single thing even though they look like they're asleep. So it's always tough until after the fact to find out what they're thinking or what's going on. But they've got a lot of medical testimony, and I would say by now they probably either really truly have some big questions or have decided this is what happened and they're ready to start deliberating.
And can you provide any sort of insight, day 14 of testimony, what's your take on just the pace of this trial so far?
Judge Cahill's done everything he could to keep this thing moving as much as he can. He's seems to have been taking breaks at about the right times. Considering we had a panic attack by one of the jurors only a couple days in, and doesn't seem like we've heard we had the other question of the jury, the second question of the juror about some posts, but to get through this trial with all the different bumps and things that have happened, it's kept going. Now we still got a couple other issues that are going to come up. There's still going to be the issue of whether or not he's going to allow him to go ahead with third degree, we've got a couple more witnesses today, and the big question whether the defendant's going to testify.
Mm-hmm. And Mike, to have cameras in the courtroom in Minnesota, it's unprecedented. Can you at all give us any sort of insight? Does that change anything, the dynamics for the prosecution, for the defense? Does it add any more pressure?
I think by now they probably, for the most part, forgot about the cameras. I don't know that.
Mike, sorry to interrupt. Yeah, court is back in session. Day 14 of testimony and the Derek Chauvin trial.
All right, we are on the record. A few matters to take care of regarding the defense case. Mr. Nelson?
Yes, Your Honor. At this time, the defense intends to arrest. A colloquy relevant to the Fifth Amendment privileges.
Yes. Just be able to do this. Mr. Chauvin, if you could use this more wireless mic. And you can remain seated for this. And Mr. Nelson, make sure you're close to the microphone.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt. Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Right. Mr. Chauvin, I'm going to address you directly because the decision whether or not to testify, I'm going to take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And he can give you advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Has anyone promised anything or threatened you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that, I'm convinced then that this is your personal decision and that you are aware of your rights. But there is a jury instruction that may be read to the jury. This, again, is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled, Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right. Anything else regarding the defense case before we proceed to talk about rebuttal? All right. We'll have you rest in front of the jury then. And we could actually take the microphone back. Ms. Voss, thank you. Thank you. We'll have you rest in front of the jury, Mr. Nelson. With regard to the state's rebuttal, it's my understanding that the state is going to call a rebuttal witness. Is that correct?
It is, Your Honor.
Okay. Whoever's going to speak to this, if we can kind of outline the topics, and if you wanted to address formally the decision regarding this newly discovered evidence. Sure. Mr. Blackwell?
Good morning, Your Honor.
Good morning.
Counsel.
I was told in chambers that there was some newly discovered evidence that the state wished to present in rebuttal regarding carbon monoxide testing. Would you tell me what that was?
Yes, Your Honor. We have blood gas evidence from Hennepin County that would contain blood gas readings for the carbon monoxide content in Mr. Floyd's blood on May 25th of 2020.
All right. And when was it discovered? How was it discovered? Why
Why
was it not disclosed earlier?
It was discovered yesterday by Dr. Baker. And what had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler. And I want to show Your Honor exactly what it was. It was in one of the slides that Your Honor can see here if I adjust the camera. And what I'm referring to, Judge, is this very last reading here on the bottom, where from the stand and the slide that Mr. Nelson prepared was the statement and the discussion that in 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%. Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of Dr. Fowler's report at all, nor a discussion about the carboxyhemoglobin content in his blood. Now, the concept of carbon monoxide was raised in the report, but not blood gas issues related to it. It was sort of discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally, but not a specific reference to the carboxyhemoglobin content in Mr. Floyd's blood. Dr. Baker heard the testimony, had not himself ever requested this, nor had the ER physicians. They explained that when somebody's brought in and blood gases are taken, there's a panel of them that are taken. The ones that get generated in the records would be the ones that the ER physicians actually request. Nobody requested carbon monoxide readings because they didn't see how that was relevant, frankly. And no one had until this testimony yesterday that was specific to the carboxyhemoglobin content of the blood and set it at 10 to 18%. Now, Judge Cahill, what everybody did have access to would be the flip side of the equation. There was information on the arterial blood gas content that showed the oxygen saturation content in Mr. Floyd's blood, and the oxygen saturation was at 98%, which meant necessarily, to the extent there was any carbon monoxide in the blood, it would be at most 2%. This was the takeaway that a Dr. Tobin had yesterday from this new disclosure, and we disclosed that to counsel, that would be something that Dr. Tobin could address based on information that everybody did have available. Dr. Baker simply then addressed the flip side of it. Was there a reading or measurement specifically on the carbon monoxide in light of this testimony from Dr. Fowler from the stand yesterday on the carboxyhemoglobin content and the slide which Mr. Nelson introduced?
Well, let me clarify one thing. When was the test actually run?
It was run the night of May 25th when George Floyd was brought in.
And you did subpoena all the records of Hennepin County Medical Center?
We did subpoena all the records.
And what they provided to you did not have that in it?
That's right, Your Honor.
Did Dr. Baker spontaneously call you to tell you that there might be something deep within the computer records that was not disclosed? Or did you seek him out and ask him for his?
We did not seek him out and ask anything. He had heard the testimony and thought that this record might exist because he thought, well, he was aware that there's a panel of the tests that are run by the machine. And then those that would go to the ER physicians would be the ones that they request to see the values on. So, but we did not contact him. It was the other way around.
And we're talking about carboxyhemoglobin readings. Is there also anything as part of that specifically about carbon monoxide concentrations?
Yeah, the carboxyhemoglobin reading would show the carbon monoxide concentrations, Your Honor, and the record, fortunately mine has my markings on it, but it would return a value for the carbon monoxide content and then would show whether or not that result is in the normal range or not. And that would be the reading in the readout from the test results.
All right. And So it specifically say carbon monoxide.
Well, it gives the letter symbols for it. So it would, if there's a clean copy.
What specifically does it say? Maybe you could just read it off the record.
It says specifically in the oximetry values, it says F, C, O, and then H, lowercase b, 1.5%, and then it gives the normal range of 0 to 2.0% as the normal range. It indicates on the record also a name for Mr. Floyd. For this record, it would be last name Bronze and first name Tennessee, because at the time the tests were run, they didn't know that it was George Floyd.
I note on Dr. Fowler's report that was disclosed to the state in February that on page 15 at the top it says, if there is a defect in the vehicle, this gas will be present, or if a person is close to the exhaust. For completeness, Mr. Floyd's blood CO level should be tested. So the state received that part of Dr. Fowler's report back in February. Is that correct?
That's correct, Your Honor.
All right. Anything else, Mr. Blackwell, before I turn to Mr. Nelson?
Your Honor, no, nothing further.
All right, thank you. Mr. Nelson. Mr. Nelson.
Thank you, Judge. Yes, for the record, in terms of rebuttal, a couple of things I would like to address. First is this new information that was just received. I would, for the record, indicate that I received these test results at 7:53 this morning. As I understand it, Dr. Fowler is on an airplane and having some difficulty reaching him at this particular moment. I have spoken with other people from the forensics panel. They're looking into these things. Nevertheless, Your Honor, the point of this is that this issue was specifically raised, as the court points out, back on February 22nd, some 20 some odd days, or 40 some 60 days. I don't even know how long it's been. I'm a little time deprived at this point. The point being is that the state has had more than sufficient notice. Dr. Fowler is opining that this could have played a role in his report. He says and suggests that for completeness, it should have been tested or should be tested. The state retained and continues to retain any blood samples. They are not within the control of the defense. The state has had ample opportunity to rebut any suggestion. As far as the information relevant to the Mr. Blackwell references in terms of the oxygen levels, the 98% oxygen levels, what Dr. Fowler testified to yesterday was how you can't rely on the oxygen levels because it's the carbon monoxide binds to the oxygen and it can give a false reading. You need this hypoxy testing, the hypoxy oxygen testing. So the bottom line is that this is information that has been within the state's control. The state has had ample notice that this could have played a part of Dr. Fowler's testimony. It is incredibly prejudicial to the defense at this point, now after Dr. Fowler has testified and left the state, to bring forth evidence. Again, the jury being the trier of the fact, Dr. Fowler was pretty clear. He was not saying that this was the cause of death. He's simply opining that it wasn't considered by the state. And apparently it was considered to be a ridiculous concept by the state of Minnesota that they didn't think to test it. Since this trial has started, in addition to this new evidence, the state has had multiple conversations with a city employee about the vehicle itself. They've gone and taken pictures of the vehicle. Again, all of this they've had ample opportunity to do, but this is what they're doing in the middle of trial, even though they've known for a long time that this was an issue. I did receive also last evening a summary of Dr. Tobin's anticipated rebuttal points that 3 of the 4 points I do not see as proper rebuttal, but we can address that later.
Well, Let's address that now, as long as I'll ask the state to respond to
Sure.
something other than your carbon monoxide issue.
Yep. So last night I received a one-page memorandum referencing a conference that they had with Dr. Tobin. It's date stamp 50417. They identify 4 areas of potential rebuttal. The first being that Dr. Tobin will testify regarding the significance of the hypoxic changes from a physiology and clinical standpoint, including his conclusion that the anoxic seizure is not indicative of a primary cardiac event based on the timeline of significant events. I believe that Dr. Tobin has already extensively testified as to his opinion of the significance of the anoxic seizure. I mean, that formed a large basis of his testimony and how he concluded that. Now, the fact that there is a differing opinion that it's a cardiac event instead of a hypoxic event that's the nature. Again, state has had ample notice. It's not rebutting. It's just simply reintroducing what Dr. Tobin has already testified to extensively.
Well, my recollection of Dr. Fowler's testimony is that he agreed that it's a hypoxic reaction, but it's just the mechanism. I think we're talking about the mechanism. Was it due to positional asphyxia versus,
Correct.
versus cardiac arrhythmia? But I think they all agreed that it was a myoclonic seizure as a reaction to hypoxia.
Agreed, Your Honor, but the mechanism being the point of what Dr. Tobin has already extensively testified to. Right. And the fact that Dr. Fowler had a different opinion, this is not proper rebuttal because it's already been testified to at length. What the mechanism of the seizure was has already been opined by Dr. Tobin.
Okay.
The second area that Dr. Tobin has indicated is he said Dr. Tobin will testify regarding the scientific research supportive of his analysis that showed how the hypopharynx can be narrowed. Again, I believe that he has already extensively testified to his position as to the narrowing of the hypopharynx. Whatever this additional research is, I have been provided with a single journal article relevant to the treatment of COVID patients that was provided to me last night as well. If it's limited to that single article, I guess that could be construed to be additional evidence. But again, Dr. Tobin extensively testified as to his view of the narrowing of the hypopharynx. The third area is what is written as follows. Dr. Tobin has reviewed and will testify as to his analysis of the 2 studies of that Dr. Fowler cited regarding outdoor exposure to carbon monoxide. Dr. Fowler testified that Mr. Floyd could have had a level of 10 to 18% carboxyhemoglobin as reflected in the slides disclosed on 413, and that in his opinion this level could have contributed to Mr. Floyd's cardiac-induced death. Dr. Tobin will rebut this analysis and provide his opinion that based on lab tests done at the emergency department, Dr. Fowler's analysis does not hold. So this email being sent at 4:53 p.m. last night, or approximately 5 o'clock last night, suggests that Dr. Tobin may have seen these test results, or the test results done at the emergency. There's no indication, is it these new test results or is it some other test result? Nevertheless, it's our position that these new test results should not go in front of the jury, first and foremost. And second, if they were, I would be moving for a mistrial based on this, because again, the state has had ample notice. Finally, Your Honor, the fourth paragraph reads, in his report regarding the size of Mr. Floyd's heart, Dr. Fowler cited 2 studies, the Molina and DeMaio study and the Northwestern study from 2021. However, Dr. Fowler did not cite the Mayo study that he referenced in direct examination, and he did not offer the opinion that Mr. Floyd had an enlarged heart. Dr. Chauvin will clarify the facts underlying these studies and their application to Mr. Floyd. Again, this is the very nature of our system, right? There's an opinion and there's a counter opinion that we both, Dr. Chauvin has already cited this study. He has talked about this study. He has talked about, he acknowledged the existence of the other studies. So this is not proper rebuttal because it's already been testified to. They're trying to recreate and get Dr. Chauvin in front of the jury again to talk about things he's already talked about. The CO2, fair enough, right, to some limited extent based upon, Dr. Fowler's testimony.
Mr. Blackwell, let's talk about those other, aside from the lab tests, those 4 points that the state is seeking to present rebuttal.
Obviously, Your Honor, we wouldn't be having any of these discussions this morning had there not been new opinions from Dr. Fowler raised from the stand. And one of those new opinions, and one which I think I was objecting to at the time, was his discussion of the Mayo study. This had to do with the whole issue of the enlarged heart, the cardiomegaly. And he had disclosed to us his reliance on Molina and the Mayo, and also the Northwestern study. That was in his report. And as Your Honor well knows, the whole point of having reports and disclosures for both sides is so that both sides have notice for what's going to be testified to on the stand. So he testified about the Mayo study anyway. He expressed his opinions about the Mayo study. It was a free kick at the goal because we didn't know that he was going there.
And what study again? Could you spell that one? Because I'm mixing up DeMayo and...
Yeah, the Mayo study is M-A-Y-O. It's as though it should be pronounced Mayo.
Okay.
And what Dr. Chauvin would talk about would be that particular study and the fact that in the opinions that Dr. Fowler had presented in his report, he didn't offer the opinion that Mr. Floyd had an enlarged heart. He offered it from the stand. He didn't offer it in his report. And had we known at the time from the disclosures that that's what he was going to testify to, then we would have addressed it during his testimony, during his direct, when he was here before.
Well, let me ask you. So, what specifically do you want Dr. Chauvin to testify to regarding an enlarged heart?
He will simply testify that if you then look at the overall studies, including the Mayo study that we've been talking about, that Mr. Floyd's heart weight does not fall within a range that is abnormal. So he'll talk about the broader sort of pool of studies in the framework of discussing the Mayo study that we had learned about, at least that Dr. Fowler was going to rely on in his testimony.
I guess one question I have is, he's the pulmonologist, he's not the cardiologist. Are you recalling your cardiologist to talk about the enlarged heart and give an opinion about an enlarged heart?
No, Your Honor, just the pulmonologist.
Okay.
And obviously there's a cardiopulmonary system, and they both kind of operate kind of hand in glove. So we felt, frankly, in the interest and respect in Your Honor's admonition, that we try to be focused substantively and temporally to simply call one person to talk about this and not multiple ones.
All right. Okay. What about the other?
On the issue of the hypoxia, for the first time from the stand, we heard from Dr. Fowler that an anoxic seizure was evidence of a primary cardiac event. Your Honor is right in what Your Honor had understood, that both sides do understand kind of what happens when you have an hypoxia event and how one passes away. What we had not heard was Dr. Fowler attributing it to a primary cardiac event. That was not in this report, and it was disclosed for the first time from the stand. And as well as relates to the hypopharynx, that was crystal clear from the stand that Dr. Fowler said, having heard Dr. Chauvin testify, I went out to canvass the literature and I found nothing there supportive of his theories for somebody who has studied the science of breathing for 46 years. So what Dr. Fowler would testify there is what is the nature of the research in that respect, in direct response to the new statement from Dr. Fowler from the stand.
Let's talk about the opinion regarding the carbon monoxide effect and Dr. Chauvin's opinion, which would appear to be within the scope of his expertise as a pulmonologist. But is it going to be solely talking about the lab tests?
It is solely talking about the carbon monoxide content of his blood, Your Honor, and I don't want to try to answer the court's question as clearly as I can.
No, go ahead.
It isn't just talking about the test results. The test results are subsumed in it, but the bottom line of what he's talking about is what is the evidence as to whether or not the carboxyhemoglobin content, the carbon monoxide content of his blood could have been in the range of up to 15%. And he's saying that based upon the medical evidence available, that was available to everybody, looking purely at the oxygen.
What was available to everybody?
The oxygen saturation content of his blood.
Okay.
And contrary to counsel's comment on the science, the way that the oxygen saturation works, we have hemoglobin, so either the oxygen is going to combine with the hemoglobin or carbon monoxide will. And if carbon monoxide has bound to it, then you can't have an oxygen saturation of 98%.
No, I understood the testimony.
So that is what he would speak to. The test results are merely corroborative of that, because the test results show a specific testing for carbon monoxide itself, and it isn't simply derived from looking at the oxygen saturation content, which is at 98%, and therefore the most carbon monoxide could have been is 2%. So it is addressing the same issue from the two different perspectives: oxygen saturation versus actual testing in the test results of the carbon monoxide itself.
Well, I agree with you that if the tests had been disclosed earlier before Dr. Fowler testified, there'd be no problem with putting that in as rebuttal. Probably there would have been no need, because Dr. Fowler would have been advised of the results and testified accordingly. So there would have been no need for rebuttal. So, but other than that, so are those the four topics, though? Did counsel set those out pretty clearly?
Yes, Your Honor.
All right, thank you. All right. First of all, in dealing with these lab test results, I find that Dr. Fowler's report gave sufficient notice to the state that the carbon monoxide that potentially was in George Floyd's blood could have affected cause of death. I read page 15 of his report, which I don't have at my fingertips at this point, that basically they said Dr. Fowler came right out and said it should be tested. That gave the state notice with sufficient time in February to either test the samples that are still there or to dig a little deeper. It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part, but it seems odd that Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper. I think their response to the subpoena was probably insufficient in and of itself. And they should check their standard operating procedures so that in the event this happens again, that they will supply all the information they have. But in any case, the defense gave notice that this was going to be an issue and specifically talked about testing the sample. The state had sufficient time to investigate and disclose, to, even if it's just because Dr. Baker called the state and said, we can actually find this, at 8 o'clock this morning, when the state is, or the defense expert is done testifying, has left the state. It's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not due to bad faith. But the late disclosure has prejudiced the defense, It's not going to be allowed. So Dr. Chauvin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple. This late disclosure is not the way we should be operating here. In that case, Dr. Chauvin may testify as to carbon monoxide if he sticks to the environmental factors, and as a pulmonologist looking at the videos, for example, and seeing Mr. Floyd's location and not knowing whether the vehicle is even on or not, which the state brought out in cross-examination. All those factors he can talk about environmentally and what the likelihood is that it would affect his carbon monoxide concentration in Mr. Floyd's blood, that's fine. But nothing about these lab test results that were just disclosed 8 a.m. this morning after the defense expert is done. With regard to the DeMaio, I will allow I have a little concern that we're having a pulmonologist opine whether it's an enlarged heart or not. But given his background, which, as I think Mr. Blackwell appropriately stated, is a cardiopulmonary system, it is a system, and I think he has some expertise in the function of the heart and its relation to the lungs. And so I think it is appropriate that he be allowed to opine whether or not the heart was enlarged or not, based on those studies, and specifically responding to those studies. As far as the scientific research, the defense did bring up as a new issue whether or not narrowing of the hypopharynx is supported in literature, and Dr. Fowler said he did a check and he didn't find anything. I think it is permissible that Dr. Chauvin be allowed to come and say, since then, since Dr. Fowler's testimony, he has done his own search, or he relied on this, and there is literature, and he can talk about the literature in a summary fashion. With regard to the hypoxic seizure, it was pretty clear from Dr. Chauvin's testimony that he had an opinion that there were movements of George Floyd's legs, that those were myoclonic or anoxic seizures due to the lack of oxygen. Dr. Fowler did not really dispute that. He also indicated that it was a lack of oxygen to the brain that causes such seizures. The only difference between the two was the mechanism. Did the lack of oxygen, was that caused by positional asphyxia versus cardiac arrhythmia? And as I recall, Dr. Chauvin excluded cardiac arrhythmia or a cardiac event as the cause of the lack of oxygen. Since he has excluded a cardiac event as the cause of the lack of oxygen, that evidence is already in the record. I don't have to remind both sides that the purpose of rebuttal evidence is not to restate what has already been testified to. It's to bring up new evidence to rebut something that came up in the other side's case. Accordingly, as to the hypoxic seizure, that's not going to be allowed. The scientific research supporting hypopharynx narrowing will be allowed. The lab tests are not allowed to be discussed, but Dr. Chauvin can talk about carbon monoxide and the likelihood of a high carbon monoxide reading based on environmental factors if he wishes, because that was gone into a great extent. And finally, the reports, and he may opine whether, in his opinion, George Floyd's heart was enlarged or not. Do we have pretty much the ground rules set?
Just one question for clarification on the carbon monoxide. There were test results that existed before the ones that are at issue from last night / this morning. What Dr. Chauvin, these are ones that relate to the oxygen saturation. So that was known before last night. And so I haven't talked to Dr. Chauvin this morning about what he's going to say or when. I might ask the court for a few minutes before we start. But what he was able to come to last night without saying anything at all related to these test results at issue was we had the results already, both sides do, on the oxygen saturation in his blood from May 25th, 2020.
Well, let me ask you this. Is his opinion going to be that when the oxygen saturation levels are this high, that precludes high CO? Because a high carbon monoxide reading would depress the saturated oxygen.
That's correct. They are would be inversely related. So a high oxygen saturation
would indicate a low carbon monoxide.
Yes.
Mr. Nelson?
As I understood Dr. Fowler's testimony, at lower levels of carbon monoxide, because the pulse oximeter does not, it's not going to differentiate based on the color of the blood between oxygen and carbon monoxide.
This is a low carbon monoxide reading because they are inversely proportional. And it's appropriate, however, to say those readings are based on pulse ox, color of the blood, color of the fingernail, and the bright cherry red, essentially confronting him with that testimony, I think is appropriate cross, but it does not preclude the state from recalling Dr. Chauvin for that purpose.
Yep, that's the clarification, Your Honor.
All right.
Thank you.
Yeah, that would be permitted. All right, anything else before? And you want a few minutes to talk to Dr. Chauvin?
If I may, Your Honor.
Why don't we start up at 10 o'clock? I assume he's close by. You could do it quickly, Mr. Blackwell.
I was hoping for a few more minutes.
I think since the defense is going to rest and you'll proceed directly to Dr. Tobin, are we calling anybody else?
No one else, Your Honor. And if we could have to 10:15.
10:15 it is.
All
right, 10:15 we'll reconvene. Thank you.
Good morning. As you just heard from Judge Peter Cahill, the court right now taking a 15-minute break. There's a lot to cover this morning. For legal analysis, let's go to trial attorney Mike Bryant. Mike, Derek Chauvin addressing the court saying that he will not testify in his own defense, and the defense resting its case. Some huge developments this morning.
I was muted. Sorry about that. I got a dog barking. Sorry about that. There's been a lot of stuff going on. The defendant admitting or not testifying, them resting their case so they didn't bring back the medical doctor, and then on top of everything else, we've got that they are the whole discussion about whether we should bring this other. They were going to allow the other witness to be brought back or not.
And can you provide a little bit more insight? So it sounds like Dr. Baker, the Hennepin County medical examiner, contacted the prosecution after hearing yesterday's testimony with Dr. Fowler, and brought up some info about some test results that may offer more insight into the carbon monoxide concentration in George Floyd's blood. Is that what I gleaned from what I was listening to?
It sounds like there was a record that wasn't given to that didn't come from Hennepin County, and that the expert called and said, hey, there's this record out there that we never got, and then they found the record, and then they were going to have him testify about what would be in the record and how that would have an impact on what was said by the defense expert. And the judge determined that they should have gotten it beforehand. They had knowledge of it beforehand, of the theory beforehand, and that based upon that, they weren't allowed to say, we didn't get this record, because they should have gotten the record. And he said that it was more an issue of potentially Hennepin County didn't give him everything, and that's their fault, but it's not something that it would prejudice the defense. And what's interesting about that is he made the statement that if they bring that up, that would create a mistrial, which hopefully, just for good or bad purposes of how the trial turns out, just because of what we've gone through, hopefully they're going to stay away from that. We don't have to look at any mistrial issues.
Yeah, so Dr. Tobin will testify again. He is a witness for the prosecution. He is an expert in breathing. So it sounds like the judge is allowing him to testify, but he will be a little bit limited in what he can say.
Yeah, he's very limited. You're only allowed on rebuttal. The state is only allowed on rebuttal to bring back witnesses to testify about things they weren't told were going to come up. So if there's a surprise, so they have to show that there was some sort of surprise, and that's why for some of it, the court said, no, you're not surprised by it. You had an opportunity. You could have gotten these things, so you don't get to go there. He kind of wobbled a little bit on the issue of the type of expert it is and whether or not he had expertise to say some of the things he was, but he decided we'll go ahead and let that in. And that saves us from having two experts come in to talk about it. And then the third thing was he did say that there was enough of a couple of items that are different enough. And because of that, he could come in and testify about those. He gave him, I think he was going to give him about 3 or 4 minutes, but he gave him about 15 minutes to go out and talk to their expert about what he can't talk about, what he can talk about, and then they should hopefully keep their questions really tight to that. And the defense will be really watching every single question and every single answer to see if there's anything that would create a problem with the testimony, either not being rebuttal or getting into this issue of the mistrial.
All right, Mike, thank you so much for breaking that all down. Appreciate your analysis. Let's turn now to Fox 9's Paul Bloom, who has also been monitoring the developments in court today. He is live from downtown Minneapolis, just across the street from the Hennepin County Government Center. And Paul, wow, some big revelations.
Yeah, big developments. I mean, I don't want to call them shocking, as I think we all would agree going into today. It was a 50-50 proposition at best that Derek Chauvin might want to take the witness stand in his own defense. And we knew they were down to at least one final witness, but now it sounds like the defense has no other witnesses to call. So I know they had a toxicologist ready to go in some respects, but obviously processing the case overnight and considering where all the testimony had come in, particularly their final witness yesterday, the expert, Dr. David Fowler, the defense is electing to rest here, but not before going through the procedural process of the defendant telling this judge and then the court that he will invoke his Fifth Amendment privilege against self-incrimination and thus will not testify in front of the jury. Now, this process unfolds outside the presence of the jury, so they have not seen it. Judge Cahill will eventually address it with them in court, the fact that they did not hear from the defendant. But this morning, Derek Chauvin answering questions from his attorney and Judge Cahill making it official. Derek Chauvin will not testify.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt. Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Wow, so there you have it. Derek Chauvin invoking his Fifth Amendment privilege. He will not take the witness stand. He will not tell the jury basically his side of the story. Of course, it's a man facing charges of second-degree murder, third-degree murder, and second-degree manslaughter. He did have to then answer questions from Judge Peter Cahill about making sure there was no pressure here, understanding that there could be an instruction to the jury explaining because you don't hear from the defendant, that cannot be used against him. Just in my experience of covering, I mean, this trial is above and beyond the other high-profile police homicide cases covered recently over the last several years in the Twin Cities, but having been in the Mohammed Noor trial, of course, he charged with third-degree murder and the death of Justine Damon, going back a couple of years before that, Geronimo Yanez, and the shooting during the traffic stop with Philando Castile. Both of those officers did choose to take the stand in their own defense to at least explain what was going through their mind. I have sources close to this defense team. I don't know how honest they were being up until this process, but had talked about it really being a 50-50 proposition and a quote game time decision on the face. I believe them. I mean, you heard Eric Nelson. I don't know if that was formal language there, but he did say they had a very long discussion about it last night. Obviously, a chance to assess the case and where they think it had netted out. And clearly, overnight, Derek Chauvin perhaps sleeping on the decision. Again, it is his life, his faith. Eric Nelson pointing out that ultimately it is his decision. And today that decision is that he just does not want to subject himself to cross-examination. He feels, at least in some respects, the defense has laid out the case that he wants to present to this jury. And ultimately, early next week, this jury will begin deciding his fate.
All right, Paul, thank you. Let's now turn to Fox 9's Leah Bino, who's also been monitoring the developments in court this morning. And Leah, new evidence presented.
Yeah, that was the debate beyond the discussion about Mr. Chauvin invoking his Fifth Amendment. The two sides, the prosecution and defense, went on to discuss for about a half an hour a couple of different motions regarding what Dr. Chauvin will be allowed back to say during this rebuttal. And basically, the main one that they started off with was some testimony that Dr. Fowler brought up yesterday regarding blood gas readings, basically looking at the carbon monoxide level in George Floyd's blood. This was something that the prosecution says that they did not have. They apparently got a call last night from Dr. Baker, who dug deeper into the report. Sounds like they thought that they had the full, complete medical report from HCMC, but apparently they dug deeper and found these readings. So now the prosecution wants to bring this in as new evidence. So we're going to show you a little bit of this discussion, because this is basically the two sides debating over what Dr. Chauvin will be allowed to say when he gets back on the stand. Take a listen.
It was told in chambers that there was some newly discovered evidence that the state wished to present in rebuttal regarding carbon monoxide testing. Would you tell me what that was?
Yes, Your Honor. We have blood gas evidence from Hennepin County that would contain blood gas readings for the carbon monoxide content in Mr. Floyd's blood on May 25th of 2020.
All right. And when was it discovered? How was it discovered? Why was it not disclosed earlier?
It was discovered yesterday by Dr. Baker. And what had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler. And I want to show Your Honor exactly what it was. It was in one of the slides that Your Honor can see here if I adjust the camera. And what I'm referring to, Judge, is this very last reading here on the bottom. Where from the stand and the slide that Mr. Nelson prepared was the statement and the discussion that in 7 minutes Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%. Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of Dr. Fowler's report at all, nor a discussion about the carboxyhemoglobin content in his blood. Now, the concept of carbon monoxide was raised in the report, but not blood gas issues related to it. It was sort of discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally, but not a specific reference to the carboxyhemoglobin content in Mr. Floyd's blood. Dr. Baker heard the testimony, had not himself ever requested this, nor had the ER physicians. They explained that when somebody's brought in and blood gases are taken, there's a panel of them that are taken. The ones that get generated in the records would be the ones that the ER physicians actually request. Nobody requested carbon monoxide readings because they didn't see how that was relevant, frankly. And no one had until this testimony yesterday that was specific to the carboxyhemoglobin content of the blood and set it at 10 to 18%. Now, Judge Cahill, what everybody did have access to would be the flip side of the equation. There was information on the arterial blood gas content that showed the oxygen saturation content in Mr. Floyd's blood, and the oxygen saturation was at 98%, which meant necessarily, to the extent there was any carbon monoxide in the blood, it would be at most 2%. This was the takeaway that Dr. Tobin had yesterday from this new disclosure, and we disclosed that to counsel, that would be something that Dr. Tobin could address based on information that everybody did have available. Dr. Baker simply then addressed the flip side of it. Was there a reading or measurement specifically on the carbon monoxide in light of this testimony from Dr. Fowler from the stand yesterday on the carboxyhemoglobin content and the slide which Mr. Nelson introduced?
Well, let me clarify one thing. When was the test actually run?
It was run the night of May 25th when George Floyd was brought in.
And you did subpoena all the records of Hennepin County Medical
We
Center?
did subpoena all the records.
And what they provided to you did not have that in it?
That's right, Your Honor.
Did Dr. Baker spontaneously call you to tell you that there might be something deep within the computer records that
Yes,
was
Your
not
Honor.
disclosed? Or did you seek him out and ask him for his?
We did not seek him out and ask anything. He had heard the testimony and thought that this record might exist because he thought that, well, he was aware that there's a panel of the tests that are run by the machine, and then those that would go to the ER physicians would be the ones that they request to see the values on. So, but we did not contact him. It was the other way around.
The state has had more than sufficient notice. Dr. Fowler is opining that this could have played a role in his report. He says and suggests that for completeness, it should have been tested or should be tested. The state retained and continues to retain any blood samples. They are not within the control of the defense. The state has had ample opportunity to rebut any suggestion.
And after that, in a little more discussion, Judge Cahill basically draws a hard line that Dr. Tobin cannot even hint about any of those lab results in his testimony when he's about to take the stand again. So that's why the state asked for a couple extra minutes, because the judge basically threatened that him even hinting at those lab results could result in a mistrial. We have some of that sound so the judge can further clarify what he is and is not allowed to say.
First of all, in dealing with these lab test results, I find that Dr. Fowler's report gave sufficient notice to the state that the carbon monoxide that potentially was in George Floyd's blood could have affected cause of death. I read page 15 of his report, which I don't have at my fingertips at this point, that basically they said Dr. Fowler came right out and said it should be tested. That gave the state notice with sufficient time in February to either test the samples that are still there or to dig a little deeper. It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part, but it seems odd that Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper. I think their response to the subpoena was probably insufficient in and of itself. And they should check their standard operating procedures so that in the event this happens again, that they will supply all the information they have. But in any case, the defense gave notice that this was going to be an issue and specifically talked about testing the sample. The state had sufficient time to investigate and disclose, to, even if it's just because Dr. Baker called the state and said, we can actually find this, at 8 o'clock this morning, when the state is, or the defense expert is done testifying, has left the state, it's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not due to bad faith. But the late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Chauvin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
You can hear some stern words there from Judge Cahill. So that's what they're doing right now, is the prosecution asked for a couple extra minutes so they can better prep Dr. Chauvin before he takes the stand again. And I would imagine, BC, probably kind of putting the fear of God in him, that do not go there. Do not hint at that testimony about those lab results, because that could result, and as you heard Judge Cahill say, potentially a mistrial, which is, of course, what nobody wants at this point, BC.
Yeah, Leah, it's certainly going to be interesting to see how all of this unfolds. Thank you. We are expecting for court to resume any minute now. In the meantime, we want to check in with trial attorney Mike Bryant for some legal analysis on some of the things that have happened so far this morning. Mike, the prosecution calling up a rebuttal witness, Dr. Chauvin, and from the sounds of it, after hearing from Judge Cahill, the prosecution, it seems, has to tread carefully.
Oh, yeah. They need to make sure that they don't get into testimony that the judge said would lead to a mistrial. So they're going to have to take it easy. And if you remember this witness does like to talk, and this witness does, head out on his own direction in certain ways. And so hopefully he's clear about what he can say and not say. And when I say that, I'm not saying, good or bad as far as the result goes. It's just that last thing anybody would want to do is have to redo this whole trial.
Mm-hmm. And just speaking hypothetically, the word mistrial, we know what that means, but can you just, for those who don't, can you walk us through what does that look like?
A mistrial would be starting the whole trial all over again, going back and getting a new jury and going all through the whole process, all back from the beginning. Sometimes cases get settled at that point because it's determined that, people get a chance to talk to the jurors that watched everything, and so they get an idea what the jurors were going to do. But boy, that's not something anybody wants to go through.
Mm-hmm. And tell me, what are your takeaways from Chauvin addressing the court this morning, invoking his Fifth Amendment right? He will not be testifying in his own defense.
It's interesting. We had 2 days in a row people taking taking their constitutional right to not testify against themselves.
All right, Mike, sorry to interrupt. Court is back in session. Day 14 of testimony.
Your Honor, at this time, the defense rests.
Thank you. Mr. Blackwell, does the state have rebuttal?
Yes, Your Honor.
You may proceed.
Good morning, Your Honor, counsel, ladies and gentlemen. The state will recall to the stand Dr. Martin Tobin. In just one moment, Your Honor.
Not a problem. Dr. Chauvin, since we are recalling you, I'm going to swear you in again. Yep. Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth?
I do.
You can have a seat again. And just for the record, if you could restate your name and if you feel comfortable, take the mask off.
Okay. My name is Martin Tobin.
Mr. Blackwell.
Thank you, Your Honor. Good morning, Dr. Tobin.
Mr. Blackwell?
Thank you for rejoining us. Got just a few follow-up questions to ask you in rebuttal. But first, just so you're introduced to the jury, you're a pulmonologist.
Correct. Lung specialist. Yeah.
Critical care physician.
Yeah, intensive care doctor.
And you've studied the physiology of breathing for 46 years.
Correct. Yeah.
I want to first ask you about the issue of Mr. Floyd's potential exposure to carbon monoxide.
Yes.
Were you able to hear testimony regarding this yesterday?
Yes, I was.
Were you able to see this particular slide in the highlighted statement at the bottom? In 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%.
Correct. Yeah, I saw that.
Would you first just tell us right off the bat, do you agree with that proposition that's highlighted there?
No, I do not.
Now, would you tell us what carboxyhemoglobin is?
Yeah. Carboxyhemoglobin is when the carbon monoxide combines with the protein in the blood that's called the hemoglobin. And so it's the combination of the carbon monoxide and that protein in the blood.
And why is carboxyhemoglobin, again, important?
It's important because when the carbon monoxide binds to the hemoglobin, it displaces the oxygen off the hemoglobin. So you need the oxygen on the hemoglobin. You don't want the carboxy, and it takes it over.
Then do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18% is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on the arterial blood gas that was obtained when Mr. Floyd was in Hennepin County.
Please, sidebar. I think the objection should be sustained, but just rephrase the question.
Thank you, Your Honor. Dr. Tobin, as you prepare to tell us why these results, in your opinion, are not reliable, could you please help the jury to understand something about oxygen saturation testing in the blood?
Right. So if you have, like was done in Mr. Floyd when he went to Hennepin County, he had an arterial blood gas obtained. So that's sticking a needle into the artery at the wrist, and you take out the blood. And then on the blood gas measurements, you measure a number of different items on that, like the pressure of oxygen in the blood, the pressure of carbon dioxide, the amount of acid in the blood, called the pH, and you get all these different measurements, and you also get the oxygen saturation, and that is how much of the hemoglobin, the protein in the blood that carries the oxygen, how much of that hemoglobin is saturated with oxygen. And we know in Mr. Floyd that it was 98% saturated.
So 98% saturated with oxygen?
With oxygen when they measured it in Hennepin County. And
So
that was 9/16, the time frame.
So if we know that there's an oxygen saturation of 98%, does that tell us anything whatsoever?
Yes,
about what?
I'm sorry, I interrupt. I apologize.
Does that tell us anything whatsoever about what the carbon monoxide content could have been at a maximum?
Yes, it does. It tells us that if the hemoglobin is saturated at 98%, it tells you all there was for everything else is 2%, and so the maximum amount of carbon monoxide would be 2%. It tells you the maximum amount of carboxyhemoglobin. That was what was mentioned yesterday. The maximum amount is 2%. It doesn't even tell you that it is 2%. It could be something else. But 2% of carboxyhemoglobin is within the normal range. You and I have levels of carboxyhemoglobin of somewhere between 0 and 3.
And so in other words, as to the statement that his carboxyhemoglobin could have increased by 10 to 18%, in your view, that's not possible.
It's simply wrong.
And it was at most 2%.
At most 2%.
Normal.
Which is normal.
New subject to discuss with you. You might recall, if you were listening to the testimony, my discussing with Dr. Fowler the hypopharynx.
Yes, I remember.
And you might recall I spent some time asking him about what research he had done on the potential for pressure on the back to narrow the hypopharynx.
Yeah, I recall that.
Do you recall him saying he had canvassed the literature and he could not find anything?
I'm sorry?
Do you recall him saying he had reviewed the research and that he could not find anything?
Yes, I recall him saying that.
Are you able to enlighten or give any information to the jury on the nature of the research on the hypopharynx and how it narrows with compression in the prone position?
Yeah. So, the research on this, which is extensive, is really in the scientific literature. It's in the physiological literature. And then that is applied over to clinical medicine. So the type of studies that are done are not really done in terms of ordinary clinical research. It's much more physiological, much more scientific of how the body works. And there's about probably at least a dozen, maybe 20 studies that show the relationship between how that if you lower the size of the lungs, you must get a decrease in the size of the hypopharynx. All of the studies show that.
And then are there studies then that look at whether the pressure on the neck narrows the hypopharynx?
No. Because when we do research, we try and do research on studies that might be puzzling, that you would be kind of expecting a bit of a surprise. If you think about sticking your fingers into your neck, you know you're going to narrow the hypopharynx. That's not kind of research that somebody is going to want to do. It's so common sense that you would know that that's going to happen. You can do it on yourself if you want. And as soon as you put pressure here, you can immediately sense that your upper airway is narrowing.
Dr. Tobin, that is all we wanted to clarify with you this morning.
Okay.
If I may have 2 minutes.
Sure. Let's do a stretch break in place.
All right, thank you so much for joining us for our ongoing live coverage of the Derek Chauvin trial today, marking day 14 of witness testimony. The court right now, the judge saying that he wanted everyone to take a stretch break. I believe everyone just kind of sitting in their seat have the opportunity to get up and stretch. Thank you so much for joining us for our ongoing live coverage. Let's bring in trial attorney Mike Bryant while we wait for some legal analysis. Hi, Mike, are you there?
I am.
So the prosecution calls up rebuttal witness Dr. Tobin, a Chicago pulmonologist. Essentially, he's an expert on breathing. The prosecution questioning him for about 10 minutes, and it looks like the defense has some question of its own. What do you think so far?
Well, it looks like they stuck to, staying away from things that were going to get him in trouble or get a mistrial. There was one objection, and now the defense, from what he said, was that he couldn't get hold of his expert because his expert was on the plane. And I wondered about that when they gave like 15-minute break, is whether or not he'd get a chance to be able to talk to somebody about what it is that has been allowed on this rebuttal. So he's probably talking to the medical people right now, or had somebody talking to the medical people right now to try to figure out, what, if anything else, he can do. Probably the most obvious things would maybe if they could do something with one of those studies that the guys quoted or said that are out there. That would probably be something. Beyond that, I don't know that there's really that much else to go into.
And so I think we're at a real critical point in the trial right now because the defense rested its case this morning. So after the questioning is wrapped up with Dr. Tobin, what happens next?
That'll be it. Then we'll get motions. We'll probably get another directed verdict motion from the defense. We'll get this whole discussion about what the charges are going to be, because there's still the question out there. The judge left to the end on whether or not he was going to allow third degree in. And then there's a whole discussion about the finalization of the jury instructions. But they'll have from now until Monday to get those, so they'll actually have some time. So tomorrow may end up, either this afternoon or tomorrow end up, may be a big working day for them to go through the jury instructions and the verdict form.
And it looks like the defense, the prosecution, some of them are taking their seats right now. Let's listen in.
There's the jury. We're going to actually have a recess now until 1:45, so we'll reconvene at that time.
And thank you so much for joining us for our live coverage of the Derek Chauvin trial. The court right now is going to take a short recess. A lot happening this morning. Just to recap, we want to bring in trial attorney Mike Bryant for some legal analysis. Mike, Judge Cahill had recently said, let's take a stretch break. The defense stepped away, prosecutor stepped away, and now another break. Any idea on what could be happening right now?
Well, what's happening right now is the defense is, I'm sure, talking to their medical people to figure out if there's anything they need to bring up or if there's any main point they can make. one of the big questions that I had was whether or not they'd be able to do something with one of these studies that this expert just said he found. And they may be scrambling to try to find one of those studies right now, which is kind of interesting because their expert said he couldn't find anything. So, you know, it'll be interesting. That'll be one of those that they might be able to do something with. But I would assume with their expert being in the on the airplane, that's what they're doing, is trying to get hold of somebody to give them more background. I mean, what's interesting in watching the motion earlier is how much medical stuff everybody knows now. I mean, the judge is talking medically, the two lawyers are talking medically. You know, they may have some background that supports that, but a lot of that's probably been learned in this trial and in the motions and in all the work they've done overall. So, you know, this is trying to get to the last couple questions, and they might be able to find something.
And Judge Peter Cahill, he made mention that, you know, the prosecution during its questioning, they really have to be careful and tread carefully in their questioning of Dr. Chauvin. Dr. Chauvin on the stand for 10 minutes being questioned by the prosecution. What did you think? Did you think that he was careful?
Yeah, oh, he was very careful. And if you looked at him, he was more restrained than he was when he was on the stand last time. And so I think he was definitely in his mind thinking about things that he had to make sure he doesn't get too close to.
And my colleague, Fox 9's Paul Bloom, has also been monitoring the developments in court, and we're going to bring him up on the screen. I know that he has a few questions for you as well, Mike.
Hey, BC, and thanks for having me hop on with Mike just here. Just as I think I just wanted to follow up quickly on what you had just asked, Mike, which was about the idea of this delay and how careful the defense and its witness, rebuttal witness, Dr. Tobin, had to be. But your belief of what you're watching unfolding here is just the defense scrambling to see how to kind of reattack the doctor on the witness stand, follow-up questions. You didn't see anything that would suggest we're going to come out of here guns blazing from Nelson asking for a mistrial. You didn't see them crossing any line with that short line of questioning, did you, Mike?
No, I mean, a lot would be these extra studies, you know, and you know, the tough thing for the defense is their experts said there isn't any studies. So, you know, this expert says there is, and the question is whether or not a couple of those are going to make a difference. That would be my guess on what they're trying to come up with, something and all that. And then, you know, when you get in these kind of really tight situations, you're trying to make sure you read it and you stop for a second and you read it again just to make sure it says what you think it says, because, you know, you can get going and think, oh, that, and then miss a word, and then boom, that blows up on you. So they're taking that extra time to make sure they do that right if they're going to ask about it.
And then my other question would just be carbon monoxide. I mean, you saw Dr. Fowler's testimony yesterday. Never did he say it was the absolute cause of death. He just had painted it as a possibility, even acknowledging under cross-examination that really doesn't even know if the car was running, if the SUV was running. How important is the issue just in general? And are you sort of surprised the state is kind of using its rebuttal witness just to attack that CO level? Is that saying to them they see that as their only vulnerability here?
Well, there's two things. They on rebuttal can't bring somebody back just to fight about everything. So they can only come back and talk about new things. So they're limited in what they can bring him back for. That's the first thing. Second is, as the state, they got to make sure they close every possible door. They can't have one juror sitting out there going, well, what about the CO2 level? No one said anything about that. What would they have said if they had been asked? So they can't have those questions out there, and since they can't have those questions out there, they don't want to leave a problem there. And then beyond that, they need to make sure that that they cover all their bases. That's really what they're trying to do. And what's interesting is the thought that there's a lot of people in listening to the trial said that this expert was the very best expert of all the experts as far as testimony goes. Now, you can take that in a number of different ways, but that's a possibility. It may be part of it to think we want to get this guy up in front of the jury one more time, so they're thinking of this guy when they go home for the weekend, because there is that certain advantage that the last witness gets, whoever it was, whether it was going to be the defendant or whoever, they're going to be the one who testifies.
And it's shaping up to be a long weekend. They're going to have the rest of this day off. They're going to have Friday all the way into the weekend. They're packing their bags. They're going to get ready. So this is critical. The one other thing I'd ask, I don't mean to take away time with BC in the studio here, is just you did hear that the judge was giving Dr. Tobin, outside of the eyes and ears of the jury, several issues he could rebut on, including the enlarged heart. There was the issue of that. He's a pulmonologist, not a cardiologist. The state did have some leeway to go in a couple of other directions, but they didn't. They literally focused on the CO. Again, I would just ask, were they just trying to get permission from the judge if they felt they wanted to go there? Or is that just literally the last hole in this case, and they're just going to leave these other topics alone that they were granted permission to question this doctor about?
They may have, when they went and talked to their expert, found that he said, look, I can't really say. And they may not wanted to give, there's a possibility they may not have wanted to give the defense any openings to come in and say, yeah, but you're not this kind of expert, right?
Right.
And so you're giving this opinion, like all these other opinions that we disagree with are based upon nothing, and that, so they don't want to give that kind of attack to him. So that may have been just a tactical thing. Could have been, they're doing all of this as much as they're prepared, as much as they're doing, a lot of this is being done relatively quick. They haven't gotten a lot of time to prep the witness after they got the instructions. They could have forgotten something, and the defense is trying to scramble to come up with information on the other side.
Interesting. Well, thank you. I appreciate that, BC.
All right, Paul, thank you. Mike, thank you. We want to check in now with Fox 9's Leah Bino, who's also been watching the developments play out this morning in the courtroom. Leah.
Yes, and for people that maybe are just now tuning in, the courtroom has been busy since about 9:15, but the jury members, they were not brought into the courtroom until about 10:19. So a lot of this discussion that we were talking about with where the line would be drawn and, what motions could be discussed, what CO levels could be discussed, all of that was taking place between the attorneys and the judge without the jury present. But we wanted to play you some of the video that was shared right off of the beginning of the day, right at 9:15 or so, when the defense officially rested, and when we heard from Derek Chauvin say that he will invoke his Fifth Amendment right not to testify. So we did get a chance to hear a little bit of him speaking in the courtroom, so we're going to play that for you now.
All right, we are on the record. A few matters to take care of regarding the defense case. Mr. Nelson?
Yes, Your Honor. At this time, the defense intends to arrest. A colloquy relevant to the Fifth Amendment privilege.
Yes.
I'll just be able to do this. So, Mr. Chauvin, if you could use this more wireless mic. And you can remain seated for this. And Mr. Nelson, make sure you're close to the microphone.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
Do you understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt? Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Mr. Chauvin, I'm going to address you directly because the decision whether or not to testify, let me take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And he can give you advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Does anyone promise anything or threaten you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that, I'm convinced then that this is your personal decision and that you are aware of your rights, but there is a jury instruction that may be read to the jury. This, again, is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't even want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled, Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right. Anything else regarding the defense case before we proceed to talk about rebuttal? All right. We'll have you rest in front of the jury then.
So again, that was a replay from this morning about 9:15 or so of Derek Chauvin deciding and officially telling Judge Cahill that he would like to invoke his Fifth Amendment right. You can hear the line of questioning there. This was a rare chance that we got to actually see Derek Chauvin without his mask on. He's been taking a lot of notes throughout this process. Very early on, right during the jury selection, they went around and introduced each person in the court. That was another rare time that we saw him without his mask on and state his name. But other than that, it's been primarily mask on, taking notes. And you also hear through the line of questioning with Judge Cahill that he's really directing his questions at Mr. Chauvin, not at Eric Nelson with the defense, because of the gravity of this decision, what is at stake, how it's a very personal decision if he chooses not to testify in his own defense, and going as far there as reiterating or reading what he's going to read to the jury during their instructions and what Derek Chauvin would like Judge Cahill to say and to tell them, because again, all of this that you just heard was taking place outside of the jury's presence. So a little bit of what happened today. It was a big day. We weren't sure whether Derek Chauvin would decide to testify or not, but now we know that he is invoking that Fifth Amendment right, BC.
All right, Leah, thank you. And the court remains in a break this morning. The prosecution, as Leah just alluded to, calling Dr. Tobin to the stand as a rebuttal witness. If you recall, he's a retired pulmonologist out of Chicago. He specialized at one point in breathing in the lungs. We want to listen to some of that testimony while we wait.
I want to first ask you about the issue of Mr. Floyd's potential exposure to carbon monoxide.
Yes.
Were you able to hear testimony regarding this yesterday?
Yes.
All right, court is now back in session, day 14 of testimony in the Derek Chauvin trial.
Just have a few follow-up questions for you, Dr. Tobin. Thank you. In terms of the carbon monoxide testing that you referenced, you would agree with me that the most common technology available in hospital laboratories for analyzing the blood is the multiple wavelength spectrophotometer, also known as the co-oximeter, correct?
Right. Yeah.
Now, in terms of your testimony relevant to the research, you referenced that there were 12 to 20 studies, and correct me if I'm wrong,
Yep.
that an increase in pressure on the lungs would increase the narrowing of the hypopharynx.
Not quite.
Okay, can you just say it again?
Yeah, I mean, it is that if you decrease the size of the lungs, that you will get narrowing of the hypopharynx.
And that research would be in physiological journals?
It would be in physiological journals. There's some journals that will be a blend of physiology plus clinical. It will be, but it's primarily going to be in physiological oriented journals.
And those physiological oriented journals would be included within the general search for medical literature?
I mean, if you go into PubMed, it would be included in PubMed, yes.
And you have not produced any of those 12 to 20 articles for the state or I to review?
I mean, I listed several articles in my report of January the 27th. There's several articles in that. I can tell you them if you want to.
Specifically that stand for that proposition?
Regarding the relationship between lung volume and the hypopharynx.
Okay. I have no further questions.
Further?
No, Your Honor.
All right. Thank you, Doctor. You may step down and you are excused.
Thank you very much.
Okay. Mr. Blackwell.
Your Honor, the state of Minnesota rests.
Mr. Nelson, anything further? No, Your Honor. All right, members of the jury, the evidence is now complete for this case. Next step for you is to listen to closing arguments and then retire for deliberations. That'll occur on Monday. The attorneys and I will still be working. We have a few administrative matters and legal matters to take care of. Most importantly, going over the law that I will give you in my instructions. And that takes quite a while. And so we are not going to change our schedule. We're not going to close tomorrow. We're going to close on Monday. And so with that, remember, you will be sequestered. We have some of your questions, and we're going to try and answer as many of those as we can. I think the one thing that you need to know today as you leave is, how much do I pack? If I were you, I would plan for long and hope for short. Basically, it's up to the jury how long you deliberate, how long you need to come to a unanimous decision on any count. And so because that's entirely up to you, whether it's an hour or a week, it's entirely within your province. So that's how I would do it if I were you. We'll also give you some information probably Monday as you retire as to other questions that don't require your immediate attention. And we will also be probably giving you some hints as far as technology. We will be operating under the rules that are currently in place regarding audio and video evidence. And that is specifically that you will be provided with a laptop computer that has all the audio and video, in fact, pretty much all the exhibits in this case, on the computer, and with a large monitor to play them. You will not have to come back into the courtroom each time you want to look at the audio or video, which is the old rules, which involves a lot of back and forth. We're not going to do that. We're just going to give you that computer with the arrangements so that you can view it as you deem appropriate as part of your deliberations. So with that, I wish you a good long weekend, and we will see you Monday morning. We will convene at 9 a.m. for closing arguments and final instructions. Thank you so much. All rise for the jury.
Good morning. I'm B.C. O'Neill, day 14 of testimony in the Derek Chauvin trial just wrapping up. The evidence in this case, as Judge Peter Cahill just said, is now complete in this case. court has adjourned and closing arguments are expected to take place on Monday. For legal analysis, we want to bring in trial attorney Mike. Oh, I'm hearing there's another development in court. Let's take a look.
The record in chambers, is that correct, from the state?
Yes, it is.
Mr. Nelson. Okay, Mr. Chauvin, you have the right to be present at all phases of the trial. That would actually include the charge conference. But basically, you'd be watching the lawyers and I wordsmithing the instructions, and I think you already have a copy. You want to be present for that, or are you willing to waive your presence?
I can waive it.
All right. We'd probably put any discussions on the record just to memorialize what we've decided, and you're willing for us to do that without you present, is that correct?
That's right.
Any requests that have already been made by the attorneys as far as proposed instructions, that constitutes a motion for me to give those instructions to the jury. So there's no need for your lawyer to object to anything, because if I don't give anything your lawyer says, that's essentially denying the motion for that proposed instruction. The same thing is true for the state. Any of their proposed instructions memorialize their request. There is no need for an additional motion objecting to whatever I decide is the final instructions. So with that, also, we have all been talking about the appropriate way to deal with questions from the jury. Occasionally, jury questions will arise. I think our preference is that we not move the jury around if we can avoid it, and also that we not have people coming and going from the government center, since you will not be required to stay here at the government center while the deliberation is occurring. Accordingly, our plan is that we do any questions by Zoom. If you recall earlier, when I brought back several of the jurors who had been selected to talk about the possible effect that Minneapolis city settlement had, that's how we would do jury questions. In other words, they would be able to see us, we would be able to see them. And when I say we, I mean the parties, yourself. But the jury, because they're anonymous, would not be broadcast to the outside world. And that would be our plan for how to answer questions. Any questions that come to me from the jury, the first step is to talk to all the lawyers, get their input on how I should answer it. Very often it is rereading certain instructions, but in any case, I will talk to all the lawyers, and after talking with them, formulate what my answers are going to be. That will be on the record, but it will be by Zoom. Are you fine with that arrangement, since you don't have to be here? We would want you to be part of the Zoom, so you've got to be subject to getting in front of a computer, basically. Are you fine with that? All right. Anything else as far as before we go into the charge conference?
Not from the state, Your Honor.
Okay.
No, Your Honor.
All right. Then we are off the record until Monday at 9 a.m. Thank you.
And day 14 of testimony in the Derek Chauvin trial has wrapped up. The evidence is now complete in the case, and court is adjourned. Closing arguments, that will happen this coming Monday. For legal analysis, let's go to trial attorney Mike Bryant. Mike, several developments this morning.
Yeah, I was looking forward to that last part, because it was going to lay out for us, hopefully, kind of the scheduling on what they're going to do. What they're going to, the lawyers and the judges have to do is get together and put together the combination of the verdict form and then also of the jury instructions. And so they'll go through, they're going to have this discussion finally of whether or not the third degree is going to be given to the jury or not. And you know, we'll kind of hear, because some of that's going to be done in a conference with them, and then they'll go on the record, and then I don't know what they'll do as far as televising the record goes, or how that'll be handled.
Mike, can you explain the sequestration process? Because today the jury is free to go home, but when they return on Monday, that will not be the case.
They'll get the closings, and the state will go, then the defense will go, and then the state will get up and be able to give a shorter version at the end. And then they're going to be sequestered, and they're going to be held together to go ahead and go through come up with a verdict.
And some of the big takeaways this morning, one being that Derek Chauvin told the court that he will not be testifying in his own defense, that he is going to invoke that Fifth Amendment privilege. Were you surprised by this? I know there'd been a lot of speculation. Maybe he would speak, maybe he wouldn't, or take the stand. Your thoughts?
In the end, no. There were a couple things that they could do on cross with him that were potential dangers. But that all being said, no, it's not a huge surprise. They were able to get in what they needed, what was said by Mr. Floyd at the scene through other videos or through other experts. So in the end, it was decided that he wouldn't testify, and he had the constitutional right not to do that, and that the jury instruction would be given. Now, one of the big reasons the judge wants to make sure it's done is he doesn't want to create some appealable issue later on down the road where a defendant comes along and says, hey, I didn't get a chance to testify, or my lawyer told me not to testify, and I didn't know I had this constitutional right. So the judge does it the way that he does is to make sure that he is confident the person understands, because they are waiving, they're invoking their Fifth Amendment right. They're invoking the Constitution, and he wants to make sure they do that properly.
And so the prosecution brought up some newly discovered evidence as it pertains to Dr. Fowler's testimony regarding carbon monoxide poisoning and the potential impact it had on George Floyd's death. And before even the prosecution brought up its rebuttal witness, the judge kind of had some instructions, it seemed, for the prosecution to be careful in this questioning. Do you think he did a good job in that?
Yeah. I mean, the judge was protecting the trial, so he was making sure that evidence wasn't coming in that was improper under the rebuttal rules, and the expert was held back. And other than there was one objection, I think, during his testimony, there really didn't seem to be any time they got close to the areas that would have put that in danger. Because in the end, nobody wants to retry this case again.
Mm-hmm. And I'd like to take this moment to bring in Fox 9's Paul Bloom, who's also been following the developments in this case. He also has some questions for you, Mike.
Sure.
Well, I was just going to start off, BC. I don't know if Leah had a chance in the last block. I just kind of thought I'd bring to our attention one comment, if you will, outside we got from our courtroom pool reporter today. There is a Floyd family member in the courtroom today. This is Arthur Reed, a cousin of George Floyd. Our pool reporter stopping him in the hallway after the decision was announced that Derek Chauvin would not take the stand. I just wanted to quote Arthur Reed to share this with our viewers. That quote, he felt that the prosecution, and I'm quoting here, would have chopped him down second by second about why he knelt on Floyd for so long. We didn't think they were going to put him on at all. Adding, quote, we're just ready to get this over with, make sure he gets the justice he deserves. We think the state has put on an excellent case. Again, that's from a cousin of George Floyd. And I guess I would ask Mike at this point, I know you guys were just discussing this idea that, that Derek Chauvin has invoked his Fifth and will not tell his story. I know it's a much bigger decision than, this jury now getting 3 full days, right? We go into this weekend, and I know sometimes it's best to put the defendant on the stand, leave that the last thought in their mind. But now we go into kind of this long stretch before we get to closing arguments. And not only that, Mike, I think about the outside world and the influences of the encroaching Brooklyn Center situation, curfews and unrest. And it's going to be hard to avoid that news and the impact that has on the human beings that are the jurors that will eventually decide the fate in this other police deadly use of force encounter. And I guess I would just wonder your thoughts. I mean, so much of this is an unprecedented trial, unprecedented case on all levels. It's unprecedented. But what are your thoughts as we kind of head into this long stretch of time where the jury will be away from the court, no more testimony, no more evidence, but the world around them continuing to move on?
Well, I mean, the jurors will be busy. I mean, they've been in trial for a number of weeks, so there's got to be stuff that piled up during that time, and they got to get themselves ready for some time period where they're going to be sequestered. So based upon that, they hopefully will have enough to keep them busy that they won't spend a lot of time worrying about what else is going on, and hopefully nothing else will happen. That's the biggest. I mean, this trial's had so many different things that have hit it. Hopefully nothing else will happen in the next couple of days. We can get back to the closings, get this trial done and done. And it's nice to hear the Floyd family. I mean, you know, nothing's going to give them Mr. Floyd back, but if they feel like the prosecutor did a good job and they can walk away feeling, you know, we did what we hope was done and it was done right, yet at least hopefully that gave them some, you know, some kind of solace, or, you know, along those lines, that, you know, because that's the big thing. We talked about this so many times. The key is to get this trial and this trial done right. And Judge Cahill's done everything possible to make sure that takes place.
And Mike, have you ever had a jury sequestered in a trial? Could you talk a little bit about the dynamics of what that does, just on how it changes anything at all, or, you know, the thought processes? I mean, probably some of our viewers have served on a jury, but not likely one that was sequestered. It's not common.
Yeah, most jurors go in fearing they're going to be sequestered. They all are aware of that possibility, but it very, very rarely happens. Basically, it is it'll two things will be important: how long it is, you know, because that'll play a big role in it. And, you know, if there's competing camps in the jury room where, you know, certain people decide or believe in one way and other people believe in the other way, then, you know, that whole, you know, being all together and everything that takes place plays a role in all of that. Now, they're only supposed to talk about the case when they're all together. So they weren't supposed to be talking about the case with each other up until now. They're supposed to wait until they get everything. And the weird thing about our system is they get a whole bunch of jury instructions. Like, they get the rules on what's going to happen after they get everything. So, you know, they get hit with a whole bunch of things. But I would guess most of them have started to develop a strong feeling towards something. And then they'll get together in the jury room and they'll start talking, and then you'll see how it goes. But to the sequestered question, it depends on how contentious that is. You know, lots of times jurors become kind of this melded group together because they spend so much time together. They get to know who gets coffee when, who goes to the bathroom when, who needs this, who has 4 dogs and who has 2 cats. You know, they know all that about each other. And if they get that kind of group, then they've created a community and it'll go along fine.
Yeah, it's interesting. You know, we see that in the pool notes and just my observations. I was in the courtroom, a week ago, and seeing just how quickly jurors had obviously become friendly, and, you know, juror in front row turning behind to talk to juror in the second row. Obviously, the masks, the COVID spreading out, you know, changes the dynamic here. And I think just taking a moment, BC and Mike, just to recognize that, like, whew, we made it through 3 weeks. I mean, in a pandemic, the civil settlement, the city civil settlement, $27 million, the incident in Brooklyn Center potentially blowing up on this case. And they got through the witness testimony, the witness evidence. Now, obviously, got to get through this long weekend. But you know, you're right. I think Judge Cahill, I don't mean to editorialize here, has run a tight ship, has kept things going. And I think taking a moment to acknowledge that they did this. In the middle of a pandemic, security around the courthouse, what it is, it's sort of a remarkable feat, even getting to this point cleanly, if you will.
Oh, it's amazing. We've got all 14, which, you know, it's going to be sad because 2 of them are going to go home.
Yeah.
As soon as the closings are done, 2 will get excused for being alternates, and they'll be gone. And so even though they're ready to get sequestered, you know, because they think they're part of the jury, they'll end up going off, and that'll be it. And you know, there may be a sense of relief. Oh, geez, I don't have to, you know, get sequestered. But boy, after all this long work, I really feel for people who have put that kind of commitment in that won't get a chance to get to the finish line.
Understood. And BC, I just know if you wanted to jump back in here on the discussion.
Yeah. I was just saying, as Mike was talking about, a lot of work has gone into getting to this point. And I know during the proceedings this morning, when Judge Peter Cahill mentioned the word mistrial, I'm not in court, but I could feel like he got a lot of attention, ears perked up when he said mistrial.
And again, I'm in the media center. I was just, you know, with 40 journalists, it's limited in terms of how many people can come in here. But all of us, there was that moment, BC. So I know the journalists covering the case were like, mistrial. What did Nelson just say? Oh, judge threatening a mistrial. You know, it definitely perked up our you know, ears here in this building. So would imagine, you know, for the parties, it sort of put them on edge to make sure they followed his orders addressing that newly discovered, I should say, CO blood evidence that Hennepin County had found, the medical examiner through the hospital records there. But yeah, mistrial, Mike, we don't want to hear that word at this point.
No, not at all. Now, what's super interesting about the whole thing is I wonder if they're going to give third degree or not. Because now is going to be the time that discussion takes place. That's the charging conference he was talking about, where they start talking about what's going to be actually given, and is third degree going to be given? And the interesting thing about the third degree is, does the defense fight the third degree coming in? I mean, if the Supreme Court in Knorr might flip the Knorr decision, I don't think they'll send it back for a new trial. I think what they'll say is the original jury was right. They had the right jury instruction, and that's the way it should have been. And the Court of Appeals was wrong about the change. I think that's what the Supreme Court would do. But if that happens, then that means that the jury instruction they give in this case on third degree won't be the right jury instruction. It'll be flipped by the Knorr court. So does the defense take the risk and say, hey, we want to give ourselves this other I mean, it's scary to allow, to not fight something to come in, but to let it go thinking we might see an appeal here.
Yeah, interesting. Yeah, you forget about that third degree murder is still sort of under content, being argued about, not just in this courtroom, but beyond. Unbelievable here that we wrapped up witness testimony, BC, but Monday, closing arguments, and this jury will get this case probably by lunchtime. And I just thought of one other interesting point as I finish up was just this idea, Mike, as you know, as a veteran trial attorney, juries have questions in the middle of their deliberations, often wanting to see one extra piece of evidence, maybe having some piece of testimony read back to them. And they'll be, it sounds like off-site, like maybe they'll do the deliberations in a hotel or off-site because they don't want to bring people into and out of the government center for security reasons, but that Judge Cahill will be addressing those questions via Zoom. So obviously we're in a new era, but something to look forward to next week, just on the logistical side, that we really won't be coming back to the courthouse until there's a after closings, until there's a verdict.
I think what he was saying, though, was that he's going to do the Zoom with the counsel. Is how he's going to deal with it. But typically the way the question comes is they write out a question. Whoever the foreperson is writes out a question, gives it to the bailiff. The bailiff gives it to the judge. Then the judge calls up the two lawyers and says, here's my question, and here's how I'm going to rule on this. And sometimes it's everybody goes, yeah, I agree with that. Or sometimes people have arguments about what it is, and you put it on the record what the question was and what the issues were, and that the judge sends back the message to the jury. And it can be everything from, we don't have enough pens to, something really vital. And what's interesting is when I'll give you an example, like in a personal injury case, that you can't bring up that the defendant has insurance. Every once in a while you get a question from the jury that says, well, does the defendant have insurance? And it's just like, I read you the instructions, just ignore it and keep going, And so some of their questions don't get answered. They just read the instructions, and that, I don't know if that's frustrating for jurors or not.
Question.
All right, BC. Oh, sorry.
I just have a quick question. I brought this up with another legal analyst that we spoke with earlier this week, just about the impact, as Paul mentioned, we're in COVID, everyone in the courtroom, they're wearing a mask. Does that have any impact on how the jury views Chauvin? And today he took that mask down to talk shortly, but does that give them another perspective of who he may be?
Well, I don't think the jury was in there when he did that.
Okay.
Yeah, I don't think. I think when he took his mask off, that was when the judge was questioning him, and that was all outside of the jury. So I don't think the jury ever got a chance to see any of that.
Do you think that at all has an impact on how, though, the jury sees him when they do see him in court and he has on the mask? It's kind of hard to get a good idea on what may be going through his head. It's all speculation, of course.
I mean, there's the extra idea that he was a police officer, and they've seen videos of him as a police officer, and they've seen him in the video, and they actually heard from him in that video that they played way back at the beginning of the trial. I think it was his discussion with Williams, so they heard some wording from him. But that's a big concern in trying cases, particularly criminal cases, is your client sitting there with a mask, and typically people beyond the Long Ranger aren't really seen as the good guys in the masks, and so it's it's a concern.
And Mike, I would just jump in, BC, real quick on that. The jury actually heard twice, Derek Chauvin in his own voice on body cameras. You're right. One time with Donald Williams, the agitated witness, the elder on the block who's trying to encourage George Floyd to cooperate at first. And he had met Chauvin kind of personally just days earlier on his way sort of away from the scene. He encountered Chauvin in his squad car, basically saying, we're good. Like, I respect you, but what was that? Keeping your knee on his, your leg on his neck or knee on his neck for, all that time. And, that we do hear a quick clip of him, big guy, he wouldn't get in the squad, had to hold him down, kind of, little snippet there. And then also he briefly had on his body camera when taking a phone call from his sergeant where it was similar, nothing serious. I don't want to misparaphrase, but, basically a quick clip in the moment that we had to do it, had to pin him down, keep him down, agitated big guy. So they heard a little bit of kind of Derek Chauvin in the moment. And as the jury is trying to build, they're going to have to be forced here to kind of build, Derek Chauvin in their own mind, right? They did not hear from him on the witness stand, so they don't have his thoughts. So you go back, well, what do you know of him? And you think about those two quick kind of clips that were captured on body camera footage. But he also comes into this case, Mike, I mean, I hate to phrase it like this, but basically, the world's most hated man, right? I mean, this jury, during jury selection, this was a case everybody knew about. Maybe not everybody had seen every second of video or every picture, but they generally had a distasteful view of Derek Chauvin. And as this defense team would have thought about putting him on the witness stand, that had to figure into their calculations of, what could this guy do to sort of rehabilitate kind of where he starts from and his posture and position in their minds to begin with. It's different than other cases where the jury just, has no idea who their defendant is. So now, they know they're kind of, I know they got an impartial jury, but still people came in with prior knowledge and prior kind of sentiments about the guy. And now they have to sort of reprocess it through the lens of what came in as evidence. And to me, the state, case comes down to, the video, nothing else. The last 5 minutes of that body camera footage, kind of are all, many of us, our instincts in first watching that is just get up off of him, that being such an essential part of the state case. And I think the defense case in the end, without hearing from the defendant, comes down to, maybe it wasn't the best policing, but let's look at the cause of death here. It's muddled, and what do you make of that? And is that enough to not necessarily convict him on these charges of manslaughter and murder? And that's kind of where my processing of where we leave things and await closing arguments on Monday.
All right, Paul and Mike, thank you very much. Let's check in now with Fox 9's Leah Bino, who's also been monitoring all the developments this morning. And Leah, all of the evidence is now complete in this case.
Yes, I kind of wanted to recap the morning for people that are maybe just tuning in, because essentially this all wrapped up today within an hour and a half, 2 hours, a couple of breaks sprinkled within that, and really the jury only in the courtroom for a few minutes between all of that. So right out of the gates this morning at about 9:15, we heard Derek Chauvin announce that, first we heard the defense announce that they rest, and also that Derek Chauvin would not be exercising his right to testify, that he would be using the Fifth Amendment right and not testifying. But shortly after that, then the state and the defense got into some discussions about the rebuttal that the prosecutors wanted to call. They wanted to call back Dr. Martin Tobin to the stand, and there was a lot of going back and forth as far as where the line would be drawn as far as what he could testify to. So we're going to replay a little bit of that for you, but essentially much of it centered around some testimony that Dr. Fowler from the defense's witness list said yesterday on the stand regarding the CO levels in George Floyd's blood, the blood gas readings. And there's some argument over whether or not that should have been allowed or kind of surprised the state a bit. So we're going to replay you some of that discussion that they had, again, outside of the eyes and ears of the jury members. This is happening in the courtroom and on the record, but some discussion they had with the judge as far as where that line of questioning was allowed to go with Dr. Chauvin. Take a listen.
Told in chambers that there was some newly discovered evidence that the state wished to present in rebuttal regarding carbon monoxide testing. Would you tell me what that was?
Yes, Your Honor. We have blood gas evidence from Hennepin County that would contain blood gas readings for the carbon monoxide content in Mr. Floyd's blood on May 25th of 2020.
All right. And when was it discovered? How was it discovered? Why was it not disclosed earlier?
It was discovered yesterday by Dr. Baker. And what had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler. And I want to show Your Honor exactly what it was. It was in one of the slides that Your Honor can see here if I adjust the camera. And what I'm referring to, Judge, is this very last reading here on the bottom, where from the stand on the slide that Mr. Nelson prepared was the statement and the discussion that in 7 minutes Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%. Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of Dr. Fowler's report at all, nor a discussion about the carboxyhemoglobin content in his blood. Now, the concept of carbon monoxide was raised in the report, but not blood gas issues related to it. It was sort of discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally, but not a specific reference to the carboxyhemoglobin content in Mr. Floyd's blood. Dr. Baker heard the testimony, had not himself ever requested this, nor had the ER physicians. They explained that when somebody's brought in and blood gases are taken, there's a panel of them that are taken. The ones that get generated in the records would be the ones that the ER physicians actually request. Nobody requested carbon monoxide readings because they didn't see how that was relevant, frankly. And no one had until this testimony yesterday that was specific to the carboxyhemoglobin content of the blood and set it at 10 to 18%. Now, Judge Cahill, what everybody did have access to would be the flip side of the equation. There was information on the arterial blood gas content that showed the oxygen saturation content in Mr. Floyd's blood, and the oxygen saturation was at 98%, which meant necessarily, to the extent there was any carbon monoxide in the blood, it would be at most 2%. This was the takeaway that Dr. Tobin had yesterday from this new disclosure, and we disclosed that to counsel, that would be something that Dr. Tobin could address based on information that everybody did have available. Dr. Baker simply then addressed the flip side of it. Was there a reading or measurement specifically on the carbon monoxide in light of this testimony from Dr. Fowler from the stand yesterday on the carboxyhemoglobin content and the slide which Mr. Nelson introduced?
Well, let me clarify one thing. When was the test actually run?
It was run the night of May 25th when George Floyd was brought in.
And you did subpoena all the records of Hennepin County Medical Center?
We did subpoena all the records.
And what they provided to you did not have that in it?
That's right, Your Honor.
Did Dr. Baker spontaneously call you to tell you that there might be something deep within the computer records that
Yes,
was
Your
not
Honor.
disclosed? Or did you seek him out and ask him for his?
We did not seek him out and ask anything. He had heard the testimony and thought that this record might exist because he thought that, well, he was aware that there's a panel of the tests that are run by the machine. And then those that would go to the ER physicians would be the ones that they request to see the values on. So, but we did not contact him. It was the other way around.
The state has had more than sufficient notice. Dr. Fowler is opining that this could have played a role in his report. He says and suggests that for completeness, it should have been tested or should be tested. The state retained and continues to retain any blood samples. They are not within the control of the defense. The state has had ample opportunity to rebut any suggestion.
You heard there, that was some of the discussion. Again, without the jury present this morning, the state trying to argue to get this newly discovered evidence into their rebuttal when they called Dr. Tobin. Here now, we're going to play you some of the sound from Judge Cahill and what he decided and where he said that line should be drawn in regard to those blood gas level readings.
First of all, in dealing with these lab test results, I find that Dr. Fowler's report gave sufficient notice to the state that the carbon monoxide that potentially was in George Floyd's blood could have affected cause of death. I read page 15 of his report, which I don't have at my fingertips at this point, that basically they said Dr. Fowler came right out and said it should be tested. That gave the state notice with sufficient time in February to either test the samples that are still there or to dig a little deeper. It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part, but it seems odd that Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper. I think their response to the subpoena was probably insufficient in and of itself. And they should check their standard operating procedures so that in the event this happens again, that they will supply all the information they have. But in any case, the defense gave notice that this was going to be an issue and specifically talked about testing the sample. The state had sufficient time to investigate and disclose, to, even if it's just because Dr. Baker called the state and said, we can actually find this, at 8 o'clock this morning, when the state is, or the defense expert is done testifying, has left the state, it's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not due to bad faith. But the late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Tobin will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
You hear some very harsh words there, and that discussion happening about 9:45 this morning, wrapping up at about 9:57. Judge Cahill was going to give the state and Jerry Blackwell about 3 minutes to prep Dr. Tobin as to where that line was drawn and that threat of a mistrial that you heard the judge say. He ended up asking for a little more, got about 20 minutes to prep Dr. Tobin. So here's some of that testimony as everyone was kind of waiting to see and watching if he was going to inadvertently even cross that line. Do you want me to pivot to, okay.
Can somebody change QC 40 to PCR 101?
Again, that was some of the rebuttal testimony from Dr. Chauvin that the state had called, trying to rebut some of the testimony that they heard yesterday when the defense called their witness, Dr. Fowler, and there was a lot of discussion about that CO level for George Floyd. So that's where things wrapped up, and a couple of breaks. But as of about mid-morning today, BC, both the state and the defense resting for this case. Lori, how can I help? We've kind of got limit. Okay.
Hey Seth, can you come in here again?
Can you just say test or something?
What's up?
Okay, don't say anything else. I feel like your mic is open on the line.
The long soundbite that we already aired? Okay. Okay. Okay.
What's that? Yeah, hold on, you guys. We're hearing. Hold on. We're on the live stream. We're hearing Leah and not the audio. Right. What's that? Yeah.
Switch to PCR 1.
We're not hearing anything on the live stream. Don't say anything, Leah.
Court has adjourned for the day. We're expecting for closing arguments to take place on Monday. For some more analysis, some legal analysis, let's turn to Mike Bryant, local trial attorney. Thanks so much for weighing in and being with us throughout this entire ordeal.
Thank you.
And so 14 days of testimony. Any big moments for you from any of the witnesses that took the stand for both the defense and the prosecution?
No, I mean, in a trial this long, there's a number of times you can look at things that are big moments. I think the use of videos. Well, first, I mean, just the precedent set by having cameras in the courtroom in Minnesota to see an actual trial in action in Minnesota. That's in and of itself a unique experience for our state. And for just legal actions overall to watch a trial. As to the trial itself, probably the videos have to have stood out the most. I mean, this is a trial that was probably created by a video that was taken, the Facebook video. But when you look at all the videos and you look at the way they put the videos together, when you were able to see George Floyd inside Cup Foods for the first time, when you were able to hear Derek Chauvin talk to the defendant, Chauvin talk to Mr. Williams after this happened. You know, there's all these video things that happen that aren't people testifying about what happened, not people having to create the image of what happened. It's actually seeing it. So I would say probably the videos are what stands out the most to me as on the overall trial. But beyond that, there's a lot of witnesses. There are a lot of people, a lot of emotion shown very early in the trial. A lot of very good experts that testified about, you know, within their expertise. And the lawyers, you know, worked hard. And then, you know, in the end, you got to give Judge Cahill, you know, all the credit for keeping this thing moving, keeping it going, getting groups together that really didn't want to try it when they had to try it. As far as timing goes, and we got to this point where we're within a couple of days of closing.
And you talked about the video evidence. That's a huge factor in this case. Jury deliberations will begin on Monday. I know that during the course of this trial, some jurors were taking notes. There was so much information, though, that they consumed in this 14-day span. Can you explain the process of, can they go back and look at some of that, those exhibits, some of that evidence? Can they hear from a witness again? What is the process?
Yeah, they get to go back and see exhibits, and the judge talked about having a computer, and they'll be able to watch video if they want to watch video again. So they'll be able to get exhibits. Now, the exhibits they'll get to see are the ones that are non-illustrative. At times, you heard where they'd introduce a piece of evidence for illustrative purposes only. That means that piece of evidence wasn't going to the jury. So the expert, the pulmonologist who testified and had the videos of the lungs and different oxygen levels and how the oxygen levels goes, that's an illustrative evidence that won't go back to the jury. They won't see that, but they'll have a chance to do that. If they want to, they could have transcript of testimony they heard read back. They'll have their notes with them, so they'll be able to bring their notes. So if someone has a particular note, they can go back and say, this is what I had for notes. They'll get a whole group of jury instructions to the rules. And one of those jury instructions they get is how to use those notes. Like, you're supposed to use your notes to help with your own memory, but listen to other people, and don't, just because it's written down doesn't make it a piece of evidence in and of itself. Mm-hmm. It's just another piece of people's memory, and people may find out that they remember things in different ways. And that'll be the first step. The jury's going to get back. They'll pick a foreperson, and then after they pick the foreperson, then they'll talk about how the process is going to be. Some jurors start off going, okay, where are we at right now, and see what the numbers are as far as votes go right there, and then figure out what they have to do to get to the finish line of everybody being unanimous.
Mike, can you give us at all any insight into what it's like being one of the attorneys, the prosecution or the defense? Do you feel a sense of relief at this point? You're days away from closing arguments, or is there still a sense of pressure that's still on because the jury has to deliberate?
Yeah, well, the whole trial, that's one of the big things that happens as a trial lawyer is you get to the point where you realize I do all this or we do all this to turn this over to the jury. And the trial's really about the jury's decision. That's really what everything is about. So you hope you put it together in the best way possible, and you got them the evidence that they needed to make the decisions that they do. Now, the prosecution has to go into it thinking and hoping that they proved their case. They proved that it was the use of force that caused the death, and that there's a connection between the death and the use of force, and that the use of force was outside what a reasonable police officer would do. So they had to prove their case. The defense doesn't have to prove their case. And, I get questions, or you see questions about people like, well, why didn't they do this? And why didn't they bring the expert in to say this? And those type of things. They don't have to prove the cause of death. They have to make sure that there's questions out there so that you can't get to beyond a reasonable doubt about it. They don't have to prove that it was the use of force that caused the death. They want, there's questions out there. If they can prove it, and it's different than what the prosecution's saying, yeah, that's a benefit, but that's not what they're required to do under the law. And, that's really not what the overall goal is. The goal is to create these questions and to create these issues out there, and for the jury to come back, and if you can't get the whole jury, get one or two of them to be on that side and say, no, I think he did what he was as best he could under the circumstances.
Considering that we are in the middle of a pandemic, as our viewers could see, the courtroom wasn't set up like a typical courtroom. There was a space made for social distancing. What do you have to say about the efforts that were put in place to make sure that people were safe, that no one got sick?
Well, it's incredible. It truly, truly is incredible. I had a huge concern about the number of alternates they had, but they got through it with the two alternates. At least we've gotten this far. We have to get all the way to the end of closings and not lose two people over the weekend. So they were able to get with the spacing, they were still able to get enough alternates that it looks like they're going to be able to get to the end on this trial. And they were able to work everything out. And from what I understand from the pool reporters, the jurors sat there with their masks on the whole time, and no one seemed to have a super problem with it. There was that person who had some anxiety issues the first 22nd day, I think it was. But yeah, I haven't heard anything else about other issues that they've had physically. It'd be interesting to see once the jury gets together and they're all sequestered together what they do with the masks, and how they feel about that exchange at that point. But you know, it's amazing. I mean, when you think, you know, how hard it was going to be to make this case go forward, and all that's been put into it for security purposes, and for, I mean, a whole giant building is devoted to making this trial work. It seems like they've done an incredible job.
And I just want to go back a little bit to some of the developments this morning. The prosecution calling up a rebuttal witness, someone that had testified before, Dr. Tobin, a retired pulmonologist out of Chicago. How often in court cases and trials do we see the defense or the prosecution call up a rebuttal witness?
Well, prosecutions tend to try to do it in a lot of cases. The big issue is whether or not there's something new that's come up, and if there's nothing new and they knew all the evidence, then they don't get a right to a rebuttal witness. So, you know, it depends on what your expert does, and depends on all the disclosures that took place. But that's you know, that's what limits it, is making sure that you don't put anything new in that they don't know about.
And that's kind of a tight rope to walk. What did you think?
Well, overall, with the amount of time, they had a lot longer for this trial because of COVID than you get in a normal case. I mean, if it wasn't for COVID, I think this trial would have tried, you know, a number of months ago, and it might have still been all 4 officers altogether versus just the single defendant. You know, they had the time to do it, but, you know, there were frustrating times. I mean, I think it was sometime last week when Nelson kind of, the defense lawyer, kind of flipped out a little bit because of disclosure issues with the state, because he's had some, what he believes, major issues with the state and how they've provided things to him.
All right, Mike, thank you. Much appreciated. And as I mentioned, what we were talking about is Dr. Tobin, a retired pulmonologist from Chicago, called back to the stand by the prosecution. He's a breathing expert. We just want to take this moment to take a listen to a little bit of his testimony.
I want to first ask you about the issue of Mr. Floyd's potential exposure to carbon monoxide.
Yes.
Were you able to hear testimony regarding this yesterday?
Yes, I was.
Were you able to see this particular slide in the highlighted statement at the bottom? In 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%.
Correct. Yeah, I saw that.
Would you first just tell us right off the bat, do you agree with that proposition that's highlighted there?
No, I do not.
Now, would you tell us what carboxyhemoglobin is?
Yeah, carboxyhemoglobin is when the carbon monoxide combines with the protein in a blood that's called the hemoglobin. And so it's the combination of the carbon monoxide and that protein in the blood.
And why is carboxyhemoglobin, again, important?
It's important because when the carbon monoxide binds to the hemoglobin, it displaces the oxygen off the hemoglobin. So you need the oxygen on the hemoglobin. You don't want the carboxy, and it takes it over.
Then do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18% is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on the arterial blood gas that was obtained when Mr. Floyd was in Hennepin County.
Please, sidebar.
And we're going to take a break in our trial coverage this morning. Governor Tim Walz is holding a press conference right now on COVID vaccination efforts in the state. Let's listen in.
death on Sunday, and the conversation and the work that's being done to ensure that these types of tragedies aren't accepted as normal and don't continue to happen in this state. Yesterday, in the midst of unspeakable and unbearable grief, I had the privilege to speak with Katie Wright, Dante's mother, who, with grace and dignity, accepted the sympathies of myself and the state of Minnesota, but also asked us and believed that we can do better, and through this process to continue to think about not just getting through the moment, which we need to do. We need to have that place to grieve, that place to speak out, that place to be angry, and to do so in a manner that allows us to protect people and property. But I will not the privilege of that conversation other than to say that very clear that the Wright family expects us to do better. Minnesotans expect us all to do better, and I am hopeful. There are things happening that make me believe that that's possible. And as I said in May, we're not going to get another chance during this time. And I know that the press here, and it's being reported early on, that it looks like the Derek Chauvin case is getting close to an end. We'll hear closing arguments on Monday, and then justice will speak. So we'll take some questions on the end on that, but I do want to note that, and I want to thank folks as we saw the ability to be able to do that, to speak your mind, to be able to express your anger, and to make it clear that folks expect change, but to do so in a manner that does not put people and property at risk. And I think folks are really struggling and trying their best to do that. And we can answer some questions and talk on that. But before we do that, I want to talk about why we're here at Workabilities. You'll hear from Commissioner Malcolm, you'll hear from Dan, and then you'll hear from Executive Director Ball, and the great work that Workability does to make sure that all of our neighbors have an opportunity to reach their fullest potential and live their fullest life, and to be in a place where they are comfortable. This was a philosophy that Commissioner Malcolm was very clear back in October when we were thinking when the vaccines were on the horizon. The idea that just through the traditional ways, even if those traditional ways are critically important to getting it to people through doctors' offices, through pharmacies, through big, large sites and things like the Mall of America or the Vikings training facility, that the way to really get to people is through trusted partners and bring the vaccines to them. And these pop-up and partner sites like the one you're seeing here are critically important. 300 folks who feel comfortable here. They've known people here for decades in some cases. The families know the folks here. The work that they're doing to bring folks into a very comfortable environment where they trust is not only getting the vaccines to the people we need and getting them out there, it's also the reason why, and I will continue to ask Minnesotans to do this, our willingness in Minnesota to take the vaccine to reach that level of immunity that we need is outpacing the rest of the country. We need to continue to do that. So this is one of those strategies. This is a site. My deepest thanks to Workabilities and to Executive Director Ball for that work. And as you heard me in there, I do think it's important to keep reminding Minnesotans that when they take the vaccine, it doesn't only move them to a place where normal is on the horizon and they can gather with people unmasked and family, it protects their neighbor. And that whole message around public health and the things we did, it's not just about you or your family's health. That is critically important, but you also have the ability to impact other people's family and health, and that seems to be happening. So I'm going to turn it over to Commissioner Malcolm, go into a little more detail, and we'll have the folks who put this site together. We'll take some on-topic questions, and then we'll stay for what you need on some off-topic. So, Commissioner?
Thank you, Governor. Good afternoon, everybody. It's just really a joy to be here at a site like this that is focused on helping people, as the Governor said, to regain their independence and to protect their health. We've known, of course, since the beginning that certain of our populations were going to face higher risk from not only COVID directly, but the other impacts that COVID has had on restricting people's independence, their ability to engage in their lives, their ability to participate in programs like this. So getting folks protected so that they can get back to those activities is fundamentally important to their physical health, their mental health, their sense of community. And it was just really more than joyful to see how excited these folks were to be be here, to be reconnecting with each other and with their staff that they've known for a long time. Getting back to the activities that are so important is part of, obviously, what we all look forward to with vaccination. But for populations that have been really struggling and suffering some of the worst effects of the isolation, this is just really impressive. I'm going to call on Assistant Commissioner of the Department of Human Services, Dan Pollock. Dan also served for many years with us at the Health Department to describe a little bit more about these community pop-up clinics. This is one of a number of these kinds of clinics that we're doing around the state to try to reach specific populations. So I'll be here for your questions later. But Dan?
Great. Good morning, everybody. I'm Dan Pollock from the Department of Human Services. I appreciate this visit and highlighting the efforts that we're making to really meet the charge that the governor and lieutenant governor have asked every agency leader. Let's get vaccination done. Let's meet people where they are. Let's help them overcome the barriers that they might be experiencing, whether those are transportation, language, lack of internet, whatever it is. We want you to be able to get the vaccine in a place that you trust from somebody you trust. So we are working. This is pop-up clinic number 20. We've done about 7,000 doses this way. We'll do another dozen of these before May, knock on wood, with vaccine supplies continuing. And it's really helping people who are older adults, people with disabilities, people from all walks of life who just have some struggles or barriers. We're going to help them overcome those. We're going to make sure they get access to the vaccine so they can have the same opportunities to get back to the regular life that everybody wants with the vaccination. I'm really proud of the work that the Department of Human Services is doing with this, and I really want to call out and acknowledge the work of service providers who are such a key component of making these vaccines be successful, making sure that people have all the consent forms they need, that their guardians are consulted, that it is a person-centered approach, and that has been so important to us. So thank you very much to Workabilities. We are doing more of these in the weeks to come at churches, at congregate dining, at low-income housing, you name it. We're going to be there, and we're going to try to get vaccine to as many Minnesotans as possible.
With that, Director?
All right.
It's your house, so you get the words.
Well, thank you very much. I'm Luanna Ball, the Executive Director here. Welcome to Workabilities. We're a day service program licensed by the Department of Human Services. Back on March 17th, we were serving about 250 individuals within the program, developmental disabilities, some complex physical needs, across 5 different programs. We reopened in July, very slowly, part-time, then went full-time. Started to hear about the vaccine in January, February. Our folks weren't eligible right then. I started reaching out to Health Department, to Hennepin County, not getting a lot of answers right then. And then Minnesota Department of Health sent me a red cap survey. I completed that, and it had a question on there about, would you be willing to host a clinic? I clicked yes. It didn't take too long, and I got a phone call or an email from somebody saying, you are interested in a clinic? I said, yeah, for my staff and eligible clients. Well, the next thing I know, I get another contact, and you have 300 doses next week. So we worked real quickly. We partnered with some other organizations, and we had 300 people signed up and ready to go for the first vaccine in March. It was wonderful to work with DHS and MDH on this. It was seamless. The vaccination program clinic, the specialists have been great to work with as well. So many of our individuals would not have been able to go to a larger facility or even a clinic. And a lot of our staff were like, I'm not going to a big place. Oh, I can walk down the hall. Thank you. So thank you to the Minnesota Department of Health and Department of Human Services, and for our special guests visiting us. So thank you.
Thanks, Executive Director. And again, I want to thank the media for continuing to tell the story of how this works and continuing to ask that more of this access. You visited some of the big sites, Mall of America, Twin Cities Orthopedic with the Vikings, our new pop-up site with FEMA. And again, these are part of it. And I think much like the FEMA site, this one is focused on equity, this idea that
You know, it takes more work to get it to some folks, but they have every right to expect that they be treated the same and that they have the same access as everyone else. And it's impossible to do that without partners who make it happen. So this is these are out there for folks. Again, I might put it out, and maybe Dan and Jan could tell them, if there's folks out there that want to do like Executive Director Ball did and you want to host one of these, then let us know. We'll continue. I'm sure you've got that. But if anybody feels like they're falling through the cracks on this, let us know. With that, I'd be glad to take some questions. And
Governor, this has been, you've been at several sites of different kinds, vaccination sites, to promote vaccination. I can't help wondering if that's a sign of concern on your part that we're going to reach a wall, that we're running out of people who are going to want the vaccine.
It is a sign of that it's inevitable that we'll reach a point where and I've said this before we even had the vaccines, we were planning clear back last year for what that would look like. And one of the ways to get against that is, of course, lots of information, community partners. But I'm convinced, as Commissioner Malcolm is those trusted partners and making it as easily and barrier-free as possible for people to get it will get us there. There was a great map my staff was showing me yesterday showing vaccine hesitancy with the colors on it. It's very clear that even across the state of Minnesota, and you could micro down to a little areas where there might be some resistance, but it's very clear that Minnesota is, as we anticipated, would be uptaking this as much as possible. But the question is well taken. Yes, we will start to get to a point. We're working in many other areas. I think, as I've said, we're pretty deliberate in everything that we did. My vaccination was not by chance that Governor Paulini was with me to make that case, and I think it's a case here on this. And continuing to listen to people and take constructive criticism and turn it into change. When people say, hey, we've got the disability community, that there are more barriers there, what are you doing to fix it? So we do take it. We do know that time will come. I think the good news is right now is that time is not here in Minnesota in any measurable way, and there is still, and if you'd go to our Vaccine Connector site, or you go to our Facebook friends who have taken upon themselves to be incredible public servants to help their neighbors find vaccines, you can go on there and start scrolling, and people are still looking and still trying to get it.
Governor, in Brooklyn Center, there was tear gas has been used, rubber bullets, a photojournalist of ours has been injured. The neighbors say that they feel like hostages in their own homes. I'm wondering if you can comment on some of that use of force. Brooklyn Center Police has been ordered not to use those tactics. Obviously, there's other law enforcement, including state patrol, that's there. If you can comment on that, if you think it's appropriate, and also journalists have been corralled and told to leave when they are not. They are exemptions from the curfew. So just a lot of chaos happening. I'm wondering if you can comment.
Yeah, I'll go to the last one first. They're not exempted from the movement orders that need to have the orderly progress of this. And let me just start by saying this. We as a state have to figure out that we never get to this situation where people feel the need that they're gathering, and those folks, and I hope we never move away from this, folks who want to gather to express their opinions on things they want to see change. And as far as the neighbors go, I have deep concern about that. I have deep concern with children breathing anything, whether it be the chemical agents, whether it be commercial grade fireworks, bricks, frozen water bottles, armored vehicles in their streets. So let's just be very clear about this. We're thinking very deeply about this. MDE and MDH are already working to provide services to those children. We have full service community schools in Brooklyn Center, so providing those wraparound services. We're exploring ways that we can help folks with rental assistance. These folks are paying rent to be up all night and to be in this situation. And now, the situation that is always the balance. Again, these very questions from you were, why didn't we do more of those things last May before buildings burned down and people lost their livelihoods and people were put at risk? We're always trying to use the least amount necessary to make sure that people aren't in a situation that becomes dangerous. Protecting personnel who are there, people who are protesting peacefully, protecting folks who are bystanders, protecting the police that are there, trying to use those in a way. As you saw last night, those were not deployed. They used some different ways of doing about it. But yes, I am deeply concerned. As far as the journalist goes, we have not had a journalist arrested. We have had folks who have been in situations, and if any of us who are all watching on Facebook Live accommodations are being made so this story is told, to hold people accountable, me as the person who's ultimately responsible, and holding people who are there to disrupt this protest by throwing things across the fence. What we need the journalists to do is to make sure that they themselves are kept in a safe place. They may be there when an arrest is being made, and they will be held for a moment, but in, I believe, every circumstance, and please let me know if this is not true, they have been allowed or been let back into covering the situation as it was. So what I would say to Minnesotans is, we have got to figure out the changes that are necessary, first and foremost, to make sure that a situation where Daunte Wright dies for a traffic stop never happens. And then we have to get to a point where we understand that peaceful right to protest and to address grievances and to make changes is heard. And then we need the folks who need to go, and I need the community to help me on this. If you're there asking for change to make sure a young black man is not killed, and you see someone with a commercial grade pyrotechnic or a frozen bottle throwing it, we need you to help ask that. And I want to make this better, so I would just tell you in this point, we're working really hard to embed you deeply in with the folks tonight. And I think one of the things that is being suggested, that we suggest, we'd like some of you on the other side of the fence to see what it looks like from the other side, or to be with folks who are there. We're working with the NAACP, we're working with the American Civil Liberties Union, and have been since Sunday night, to have them side by side and work with us. So ultimately, I take full responsibility, and each jurisdiction does their own thing. But I just want to say, we have not had businesses burned down. We've not had other people seriously injured or killed. And we're trying to use the least amount necessary as the situation warrants, but making sure that we're understanding, and we're starting to see that folks who are there to use this as an opportunity to disrupt can't be allowed to do that. So we'll continue to work on it. I certainly will not make the claim that this is perfect. I certainly would wish, as long as every day I've given the privilege to be governor, I never have to call out anyone to have to do this. But when a tragedy like this happens, and I think all of us recognize, next week is going to be trauma-filled, it's going to be tense, and we're going to have justice render a verdict next week. However that turns out, there are going to be emotions. And what we need to ensure is that First Amendment and constitutional rights are protected, grievances and anger and trauma are given a place to be expressed and dealt with, and that those folks who would use that as an opportunity to try and repeat the destruction and the chaos and the fear, I just have to tell you that, and the Lieutenant Governor's been very clear about this as a mother, she is, and our team is thinking about trauma folks and making sure my team that's been around this the whole time of how terrifying it must be for those children in that building as this is going on. And I think all of us need to think about this. It's simply where that facility was built, but this is traumatic. And I can tell you, had that building caught on fire, we could have had that tragedy. So we'll continue to do the best we can. I continue to ask Minnesotans to help on this. I do think, and I want to extend again, the legislature together is picking these things up and moving things, and that's what people are asking us for. If they don't have a place to see some of this change, then we see the things that happen on the streets.
Governor, there's a spat, I'm sure you're aware of, between Brooklyn Center officials and the Hennepin County Sheriff now. Brooklyn Center officials aren't happy with the way the sheriff is handling the police response. The sheriff says all of these changes in city government that have happened this week are creating serious confusion. Is that something that you're getting involved with, the state is getting involved with?
Well, I certainly track it, and I don't want to note to this that to Mayor Elliott and to the folks of Brooklyn Center, a trauma and the death of Daunte Wright and the trauma that brought has thrust them into the international spotlight. There's obviously, early in those days, who reported to who as they were starting to try and deal with the police. That was obvious. I think there's great angst around how do you deal with this. Again, having people be able to express this deep trauma they have, but making sure that we don't have buildings burned and looted and people put at risk, does cause some tension about the decisions that are being made. I spent yesterday talking to advocates, as I said to Ms. Wright. I also called 26 West Metro mayors who don't know if this will be their community yet, and we're all in this together. There needs to be a cohesive way to to make sure that that peace is kept. I also think there needs to be a cohesive way to make sure that there's accountability in speaking on this. So candidly, we're hearing that, obviously. I will say that folks are working together in a very professional manner. The law does allow the statutes for Hennepin County is responsible for that, and these other mayors that I was calling to make sure that we're all on the same page there, and they were all to a person said, yes, we understand this. So we'll continue to monitor it. My hope, again, is and am grateful for, Mayor Elliott was thrust into a situation that no mayor in America, I don't care if they're the mayor of New York City, Los Angeles, or smaller communities, an untenable situation of both scrutiny that's there, trying to protect his citizens, trying to deal with the trauma, and I think they are doing the very best they can. So yes, we're continuing to talk, continuing to work, and continuing to try and support in any way.
Is there a reason you haven't appeared with the mayor yet? And what assistance are you giving them? Obviously, it's a small city government there.
Yes, anything they're asking for, and trying to hear them out. I have spoken to the mayor. The new acting city manager, as chance would have it, is someone that I have known for 25 years from Mankato. So we have been on with them. We had the Operation Safety Net leadership teams on there, other officials who could be on there to talk. I think this is one of those situations, and I want to be very clear of trying to respect local authority but keep this straight. It can become confusing, and just candidly, Mayor Fry and I are working together on that. He's a dear friend. I trust him. We're working on all of this. It gets a little bit tense, and what I want to make sure is that we don't send a mixed message that's not really the case and it's in the emotion, and that we are working together. And I know the mayor is expressing the desire of his citizens. This question around the use of non-lethal force or the chemical weapon, this is a real question, and we don't want to deploy those. Our guidance is only when absolutely necessary to diffuse a situation that become much more dangerous for everybody involved, and to be very, very judicious about that. I do think one of the things that I learned in May is that as an elected official, you can't set away from this and put people out there whose lives are in danger and not allow them to make some of those decisions. Now, they may make a decision that is incorrect, and at that point in time, the elected official who is responsible needs to say we're responsible. And so I think what we're trying to do on this right now is make sure that chain of command stays in place, give the space necessary for this community to start to heal. Pretty dramatic when you have a city manager leave and a police chief in a community this size. And I think that the folks that are helping, trusted friends out there are trying to make the case. And again, I am here at any opportunity and continue to get on teams and speak.
Governor, did any of the criticism in using tear gas cause you to say don't use it last night? I know it wasn't used last night. And also, are you looking at how to use some of these things, like you said, next week when countries are behind it?
Yeah, well, there's lots of things you want to do, and I just want to be clear, as I said the other day, I've seen many cases, and you have too, both here and other places, when these things are used without a clear goal of what they're trying to do, and they're used indiscriminately to just panic a crowd. I trust our public safety officials to be very judicious and think about this. One of the things as we talk about is that you can try and be as specific as possible. Wind and those types of things, move it around. I continue, no different than I did in the beginning last year, and I continue each night, is to give the guidance that we need to protect people's rights to petition their government and First Amendment rights, and we need to strike that balance of making sure no one and no property or no people are put in a situation. And if that means deploying these at a critical time, that needs to happen. But I've made it very clear that we will be held accountable. I will be held accountable of some of the things we've seen where somebody just indiscriminately drops one on someone who's just standing there and wasn't part of it. Now, the thing I would caution us all in is trying to understand what that threat was. It looks pretty innocuous when someone has a line of umbrellas. It gets a lot more dangerous when someone pops up and throws a brick from that line of umbrellas. So I'll continue to ask that. I will continue to say, again, we've got to get to a point where these types of situations don't happen. But I do think those non-lethal means create a space in there to defuse really dangerous situation that might. I would ask all of you what you think would have happened Sunday night or Monday night, especially, had there not been a fence there and there had been no one there. I again, it proving a negative, but I've learned from the past that building would have been burned down, and my fear is the surrounding apartments would have burned too.
2 minutes.
Governor, if I may ask, flopping back to the other question, the high school league today said that outdoor athletics can happen without masks. I wanted to get your comment on that, but also, is it time for a rethinking of the broad mask mandate and something more tailored or sophisticated?
No, on the broader mask mandate. I'm just going to tell you, masks are our cheapest, most just less of. They're just the best way to do things. It doesn't take a lot. That has the biggest impact. And the indoor mask mandate has worked. I will absolutely. We have the data to show it has reduced our spread. We do know that outside like this. That it's much safer, but at this point in time, no, now is not the time to do that. Our variants are relatively high. We have hospital groups that, as Commissioner Malcolm would say, we're meeting about once a week, are now meeting daily, and we've had 42 requests for transfer.
115, I think.
Now, okay, which we had zero a week ago. So we have hospitals that are cross-balancing, cross-leveling beds because we're at that point, and the surest thing we can do, mask first and foremost, social distancing, hand washing. I will thank Minnesotans. Our testing numbers are going way back up again. And then, of course, the reason we're here is vaccinating. But at this point in time, no thoughts to turn back a mask mandate.
Last question.
Your response to the Johnson & Johnson vaccine with the people that are having bad reactions to it?
Yeah, again, I thank CDC for being very transparent. Vaccine safety is the utmost importance on this. We have had, I believe, still at this time, 6 reactions to about 7 million doses of that. As I said the other day, I take that very seriously, that we would have some of these reactions, but I'm hoping CDC is doing their work, evaluating and making sure. Myself and my family had Johnson & Johnson. I just candidly am concerned, first and foremost, they get that worked out. And if these are incredibly rare side effects, we do all we can to alleviate those or to steer people who might be in that group to another vaccine. But I do worry if it creates vaccine hesitancy that slows us down, because I think there would be a strong argument to be made that we had 6 people get sick by this. We may lose a large number of people because they weren't willing to take not only Johnson & Johnson but another vaccine. So I have concerns. We've expressed those to CDC. I was hoping we'd get an answer today, maybe, and I don't know, Jan, if there's anything more to add to that, but it is a concern. We need to get it back on. I would remind Minnesotans, though, that it makes up less than 5% of our doses that are being delivered at this point in time.
Governor, if I may, just really quick.
And this is it then.
Teddy is not happy with me. You had a conversation with Speaker Wortman and Leader Gazelka in the Senate. Senator Gazelka told reporters that he's committed to fact-finding hearings on police reform, not promising any bills being passed. You expressed with urgency that something needs to happen. What is your response to that from Senator Gazelka, and what are specific policies you think could be passed very quickly in the legislature?
Yeah, I would first of all, and I can't speak to what can pass in the legislature necessarily, but I do think it's important in this moment. I am appreciative that Senator Gazelka has taken this step, because it was only a couple weeks ago we heard, no, nothing more is going to be done. That's not what the public's saying. That's not what the public wants. Now, the senator has the prerogative as the leader, majority leader of the Senate, to decide what that's going to look like. I would just caution about things being perfunctory and checking a box rather than having an honest conversation about things that might work. And they extend from changes to qualified immunity through a whole litany of things that policy experts and other localities across the country, Maryland being the most recent one, have shown can make a difference. The public is asking for us to do a very simple thing. Don't ever lose track of all of these conversations we've just had. All stem from the fact that we made changes in July, but Daunte Wright is still dead. And again, we may never get to absolute 100% on things, but I think as Mrs. Wright made very clear, we got to do better. So I don't want to speculate on what they can get done. I do think it's a good first step, and I think those of you who heard of that conversation, Speaker Hortman was not happy with me because there's been a lot of work done in the House of Representatives around this. It just hasn't moved in the Senate, and I think she rightfully took some offense to the fact that I lumped the entire legislature together, which I would note is something executive branch tends to do. But in this round, I think that conversation, and I would just say to close this out, I left that conversation more hopeful than I've been just in, not just around police accountability, but just our ability in Minnesota to kind of get back to that very unusual place we were last year, where there was a lot of collegiality, there was a lot of trust, and there was some really candid heart-to-heart conversations happened on that. And I think Senator Gazelka turning around and at least moving that far, and that was one of the reasons I didn't want to, I asked the legislature to do this without jamming up or pointing at people, but it's very clear that I wanted the Senate to move a little bit. They're doing that. So I think for Minnesotans to know is, at least I'm hearing this loud and clear, we cannot allow this to continue to happen to black young men. We can't allow it to happen to anyone, but we do know that right now is that I don't think it's much of a debate. You're less safe to be black in Minnesota than you are to be white right now on these things, and they're asking, are there some changes that we can make both legislatively and culturally that will start to reduce that? So I have to tell you, it's a good sign. There's a lot of reasons for us to know that this is an opportunity to fix some of this. I would ask Minnesotans again, the next week is going to challenge all of us. It is going to create trauma. Please, those of you, take care of yourselves, take care of others. Think about it if you're feeling these things. And for us to try and show the world that we're willing to take this on, we're willing to look to what our weaknesses are, especially around this issue of racial equity and policing, and figure out a way to fix it, rather than continuing to have discussions about the tactics after the situation has disintegrated into large crowds standing off against each other in residential neighborhoods with children who should be sleeping safely, peacefully, and ready to go to school the next day. So we'll continue to work on that. I'll send my final thoughts to Executive Director Ball. Incredible work here. Thank you for showing the dignity of this. This is the stuff that Minnesota does as well as any state. These are the types of leadership things that we do in these day facilities and our human services, that we invest in people. We take care of our own. We try and get this right. There's reasons for us to have lessons of these types of things that work that I think can extend broader into this discussion around public safety that should be tied into that common bond together. So thank you for modeling for us. Thank you to all of the folks here who do the hard work, and we'll be back again soon.
Okay, thank you, everybody.
Thanks,
Could I ask
Yes.
one last thing?
Yeah.
Swag bag. Here.
in the state. He also addressed the fatal police shooting of Daunte Wright in Brooklyn Center this past Sunday. We will, of course, bring you all of the latest headlines coming up with a special edition of Fox 9 News. In the meantime, our coverage of the Derek Chauvin trial continues after 14 days of testimony. The evidence is now complete in this case. Court has adjourned, and closing arguments will take place on Monday. For now, we want to show you some of the earlier testimony from today. It's with Dr. Tobin. He's a retired Chicago pulmonologist.
I want to first ask you about the issue of Mr. Floyd's potential exposure to carbon monoxide.
Yes.
Were you able to hear testimony regarding this yesterday?
Yes, I was.
Were you able to see this particular slide and the highlighted statement at the bottom? In 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%.
Correct. Yeah, I saw that.
Would you first just tell us right off the bat, do you agree with that proposition that's highlighted there?
No, I do not.
Now, would you tell us what carboxyhemoglobin is?
Yeah. Carboxyhemoglobin is when the carbon monoxide combines with the protein in a blood that's called the hemoglobin. And so it's the combination of the carbon monoxide and that protein in the blood.
And why is carboxyhemoglobin, again, important?
It's important because when the carbon monoxide binds to the hemoglobin, it displaces the oxygen off the hemoglobin. So you need the oxygen on the hemoglobin. You don't want the carboxy, and it takes it over.
Then do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's...
This is Fox 9 News.
Good afternoon. Happening right now, the family of Daunte Wright and their attorney Benjamin Crump are holding a news conference in Minneapolis. This is ahead of the first court appearance of former Brooklyn Center police officer Kim Potter. She has been charged with second-degree manslaughter in Wright's death. You see that the family has gathered, and Benjamin Crump is standing. He's the gentleman standing there in front of them, and he will be addressing these charges today. Let's listen in. It looks like they're about to get started.
Is everyone ready? I'm Attorney Ben Crump, along with Attorney Jeff Starms and our other co-counsels. We represent the family of Daunte Wright. Present with us today is Daunte's mother and father, Katie and Aubrey Wright. Also present, who you will hear from, is Daunte's aunt, Naisha Wright. Also present is his grandmother, Angie, and his brothers and sisters, and Uncle Bobby. Their family from all around Chicago, Houston, a big, beautiful family coming to have to deal with yet another tragic killing of an unarmed black man. And so we got many requests from the media, the family's response to Officer Potter being charged with second-degree manslaughter for the killing of Daunte Wright. Yesterday, I was in New York at National Action Network's convention, having a panel with Reverend Al Sharpton and the mothers of the movement, as they are often referred to. And while we were on the panel, Katie, and they was answering the question, what message would you have for Katie Wright now that she is joining a sorority that no mother wants to be a part of? And maybe it was fate, as they were answering those questions, that we got notified that County Attorney Arput had filed the charges against Officer Potter. And I told them, Michael Brown's mother, Leslie McSpadden, Michael Brown was killed in Ferguson, Missouri. Many say he had his hands up, and the phrase "hands up, don't shoot" went viral. Eric Gardner, mother, Gwen Carr. Eric got choked in Staten Island, New York. He said, "I can't breathe," before George Floyd said, "I can't breathe." And Sequette Clark, the mother of Stephon Clark, who was killed by the police in his grandmother's backyard as he was running away. And we're fortunate to have Stefan's brother, Stefante Clark, who came from Sacramento, California, to stand with the family of Dante Wright. But it is because of these women fighting for justice for their children, their dead black boys who were killed unjustly by the police in those instances. And neither one of them, not Eric Gardner, not Michael Brown, nor Stephon Clark, Attorney Storms, got their day in court. They got no due process. They didn't get to have the officers come before the court of law and have the witnesses and evidence presented to a jury to make a determination whether they would have any criminal liability. And the blood of Stephon Clark, the blood of Eric Gardner, and the blood of Michael Brown is on the hands of the American criminal justice system, because there was no accountability for the police who killed them. The only question that we have before us today is, will Dante Wright name join that list of black people in America who have been unjustly killed by the police, who did not have the police held accountable? But we are heartened that because of those individuals and raising the consciousness level that our children's lives matter and that black people's lives matter, because of that, we believe that we're starting to see a change in America. Because, like I said, they didn't get a charge and an arrest, but Dante Wright did get a charge and an arrest of the officer that shot and killed him. So we are making progress, and I want to encourage those protesters, those young people, those activists, that you're making a difference in Minneapolis, Minnesota, right here now, is ground zero for that change. And I know Katie, and I know Aubrey, it is so difficult to see the glass as half full in this most regrettable time that you are preparing to go to the funeral home to see Dante for the first time since this tragedy. It is so very difficult to see the glass as half full. But just know, here in Minneapolis, George Floyd's killer was arrested and charged, and we're now waiting for closing arguments in the trial of Derek Chauvin to make sure that George Floyd got due process of the law, got his day in court. And the fact that because there were charges, that you all will get your day in court. And that's very important, that marginalized minorities in America get their day in court so we can live up to our promise of liberty and justice for all. Well, that means Dante Wright, that means George Floyd, that means all the others, whether it be Stephon Clark, Michael Brown, Eric Gardner, Terrence Crutcher, Alton Sterling, Laquan McDonough, Philando Castile, Corey Jones, Raquel Boyd, Natasha McKinney, Sandra Bland, Pamela Turner, E.J. Bradford. So many of our children have been killed by the very people who are supposed to protect and serve them in very questionable, highly controversial situations. And so when we think about this moment, Naisha, everyone continues to ask the family, well, are you satisfied with the charges? What do you think of the charges? All we can do is say we're making progress. The journey to justice is a long one. If you consider apples to apples, Attorney Storms, you had Officer North here in Hennepin County he shot a white woman, Justine Diamond. Apparently it was in a dark alley. He shot and killed her. He showed great remorse, said it was an accident, did not mean it. He was charged with third-degree murder and convicted of third-degree murder and sentenced to 12.5 years. Now present before us, we have Officer Potter, a white police officer, kills an unarmed black man, and she's charged with second-degree manslaughter. Whereas we understand that if convicted, she can get between 4 and 10 years. All this family is striving for is to get full accountability, to get equal justice, nothing more or nothing less. This family know that really, as Aubrey and Katie talked to Attorney Storms and I about what is the most time she could get, what are the highest charges after they met with the district attorney. They concluded that really there's no justice for them because justice would mean Dante not being killed. So the only thing they can ask for, Stefante, is full accountability. As Naisha so eloquently stated, accountability to the highest level. That's all they can ask for. That's all they can request. That's all they can demand. And so they will do that because Dante Wright life mattered. You think about Officer Orr and his circumstances, and then you think about Officer Potter and the circumstances of her killing Dante Wright. And the illustration is just so graphic. You didn't have all of this. You did not have all of this in Officer Noah's situation. It was daylight. You see a gun, a taser, a Glock 17, and a taser. So it's very difficult for this family to accept that this is an accident when you have a veteran who's been on the police force for 26 years. And we still believe that it was over-policing. It was an excessive use of force because we have a propensity in America to over-police marginalized minorities, especially black men. And again, we're trying to compare apples to apples. If you go to my Instagram page, and people have been doing it a lot, at Attorney Crump, we have 3 videos of young white men not only resisting the police, but they are assaulting and battering the police. They have weapons. They reach for a gun. And yet, the police still don't shoot those young white men. In fact, in some of the videos, the police actually retreat. They run from the white men. So why is it in every instance that the police engage in the most excessive force with black people? Think about what we just witnessed in Virginia with the Army veteran. Most of our white brothers and sisters who get pulled over by the police, they give them a ticket. And then they go on their way. But for some reason, marginalized minorities are made to submit. I don't know what it is in the mentality of police officers that they want black people to submit to their will. When you think about George Floyd, it was an alleged $20 bill, counterfeit. They could have given him a ticket for that. It was at most a misdemeanor. They don't even know, they didn't even ask them, well, it's alleged this is a counterfeit bill. Did you know it was a counterfeit? They didn't ask them that. You heard the cup food employee say, I don't even think he knew that it was a counterfeit. They could have asked George Floyd, do you have the money to pay for it? But no, he didn't get the benefit of consideration, the benefit of professionalism, the benefit of the courtesy, the benefit of the de-escalation that we see so often with white American citizens. He didn't even get the benefit of humanity. And if you ever want to know the difference, just go back and look at the white nationalists attacking the citadel of our democracy on January 6, 2021. So it's not about do they know how to de-escalate. The question is, why don't they de-escalate when it's Dante Wright? Why don't they de-escalate when it's George Floyd? Why don't they de-escalate when it's so many black people who are unarmed? And so we're here to answer those questions. And finally, we ask that you keep the family in prayer, all his family. Keep little Dante Jr. in prayer as they get ready to go through one of the darkest chapters of their life. Literally, after they leave this press conference, they're going to the funeral home to start to make the arrangements to give Dante the respect in his homegrown services that he did not get from that police officer. You're going to hear You'll hear from my co-counsel attorney Jeff Storms before we hear from Dante Wright's parents. Attorney Jeff Storms is a great attorney here in Minnesota who I've been blessed to work with also in representing the family of George Floyd. He is one of the best lawyers I've ever had the honor of working with. Thank you so much, Jeff.
I've had, I think, what I might refer to as the unfortunate privilege to work with a family I love and the family of David Smith, who died here in Minneapolis. And Mr. Smith's family did not receive equality. They did not get their day in court for a criminal trial with respect to the officers. Now I've had the opportunity, and again, a privilege, but one I wish we didn't have, to stand next to great families in the Floyd family and the Wright family, and incredible attorneys like Mr. Crump and Mr. Romanucci. And now we've seen two families who are getting some justice. They're getting criminal charges. They're getting a day in court. But we shouldn't be patting ourselves on the back for baby steps towards equality. This isn't the result of enlightenment when you think about the history in our city. The Damon case confirmed what the black community, what our black brothers and sisters always knew. If a black officer killed a white person, they'd be charged. And so the hand of the city, the hands of the county were forced. They now must give at least some level of equality when the situation is reversed. So even though we can take some small comfort in that baby step towards equality, it doesn't bring Dante back, it doesn't bring George back, and it's of little comfort to many families, like the family of David Smith, who did not get that opportunity. Thank you.
Thank you, Jeff. Thank you, Jeff. Very well said, Attorney Storms. This is very emotional for them. His parents, Dante Wright's parents, Miss Katie Wright and Mr. Arby Wright will now address you briefly.
The last few days, everybody has asked me what we want. What do we want to see happen? And everybody keeps saying justice. But unfortunately, there's never going to be justice for us. The justice would bring our son home to us, knocking on the door with his big smile, coming in the house, sitting down eating dinner with us, going out to lunch, playing with his 1-year-old, almost 2-year-old son, giving him a kiss before he walks out the door. So justice isn't even a word to me. I do want accountability, 100% accountability. Like my sister said, the highest accountability. Amen. But even then, when that happens, if that even happens, we're still going to bury our son. We're still never going to be able to see our baby boy that we're never going to have again. So when people say justice, I just shake my head. Do you want to say something?
Thank you, Katie. Mr. Wright is going to defer to his sister, Naisha, to speak on his behalf, and she has demonstrated with raw emotion the pain and the agony that this family deal with, that many families deal with. Stefante experienced it with his brother, and Trayvon's mother experienced it with the loss of Trayvon. And these families, to us, it's a case, it's a cause, it's a hashtag. To them, this is their blood. And it hurts. It hurts really bad. So please give the charity of your undivided attention to a young woman who is speaking for her family and for her nephew, Miss Naisha Wright.
I want everybody to sit here and imagine you having to bury your child that somebody just murdered. We all know when our children are born, we're so proud. Fathers, they want their baby boys. Us moms, we get that love from our sons. They don't get that anymore. Justice, what is justice? Do we get to see Dante smile? We don't get to see that. Do we get to hear Dante joke again? We don't get to hear that. The highest accountability, I know the highest is going to be being judged by God. But can we get a conviction?
Can we?
Can we get something? Manslaughter? Y'all see the difference? This is a taser. This is a taser. But no, my nephew was killed with this, a Glock. These two are hurting, our family is hurting, our blood has been spilled, and all we ask for is to please just keep getting his name out there, and please help us to go ahead and get something done, a conviction, something. And if this was Potts, I'm not even gonna call her officer. Because at this pot or whatever, if it was her child, if someone killed her child, we wouldn't even be having all this press conference, no, none of this. Because whoever that would be under the jail again. Can we get that same thing? I don't care what's said, what my nephew may have done, whatever it is. Again, he was ours. He was a good boy. He was ours. We want the same conviction that anybody else of our race, or even outside of our race, what they want to call a minority, would get. Not a pat on the back. Unfortunately, my nephew didn't get a drive to go to Burger King to get something. He didn't even kill nobody. It's so much I want to say, but because we in the house of the Lord, and I pray all day and I pray every day, my brother and my sister need this woman to be convicted. If we can have life, we want life. We gotta go life without him. We gotta go life without him.
Thank you, Naisha. You can see how emotional this is. But Naisha asked me when we were talking earlier if Officer Potter had children. I didn't know the answer. But she then said, well, if a police officer did Officer Potter child like they did her nephew, what would America demand? It's a fair question, America. What would you demand? Well, whatever you would demand for her child, then why shouldn't Katie and Aubrey be able to get the same? Isn't that what equal justice under the law means? And Aisha raised another profound example. you have these young white men. She was talking about Dylan Roof in a church similar to this, shot 9 black people. The police followed him across state lines. And when they apprehended him, they didn't shoot him in the back jail. They didn't kill him. They apprehended him alive, and they gave him so much consideration that they took him to Burger King to get a burger and fries, because they, for whatever reason, treat white Americans differently than they treat black Americans. The Parkland High School killer, they followed him. They took him alive. The white man who just killed the people in the Asian spot in Atlanta, they took him alive. But yet, when you have a black person, Stefante, who ain't killed nobody, they shoot first and ask questions later. And then they come up with a way. I know this is extreme, but they come up with a way. They come up with a way to justify over and over again the killing of black people in America. Over and over and over again, they come up with a way to justify it. Where we're done accepting the justifications, America. As I said, everybody keeps saying, well, no matter how tragic it is and how unnecessary it is that Daunte Wright was killed, they continue to say that looting is unacceptable. Well, you know what we say is unacceptable? Killing unarmed black people. We want President Biden to always add that to the narrative. We want all our leaders, the governor, everybody to say it's unacceptable to destroy property when you kill our children. Well, we want you to add to that it's unacceptable to kill unarmed black people. Enough is enough. We're just outraged that during the Derek Chauvin trial, regarding the killing of George Floyd, Attorney Storms, 10 miles from where this pivotal case of American jurisprudence has taken place, one of the most important consequential cases in the history of America, dealing with police excessive use of force. You would think that the police would try to do everything in their power to use the best standard of care, that they would be as professional as possible, that they would use every measure of their discretion to de-escalate situations. But you have this trainer training other officers here in Minnesota. She's not training them apparently based on this to be de-escalating. There was no reason to use that taser. They had his identity. They knew the tag of the car. So what if this young kid got away? They knew how to get him. It was a misdemeanor. We are very suspicious of every aspect of this stop, especially considering COVID-19 pandemic, where people are having challenges trying to get their license tabs renewed. It's a lot of people in Minnesota driving around with expired tabs right now because COVID-19 had everything shut down. But as Naisha and I discussed, Stefante, They believe driving while black was the reason he was stopped. And we have to deal with that, America. And I know people
You've
say,
been listening
oh,
to Benjamin Crump. He is the attorney for the family of Daunte Wright. He has come into Minneapolis today to hold this news conference with the family to give their reaction to the charges against Kim Potter of second-degree manslaughter. While we didn't get a very specific reaction to that, his aunt, Daunte's aunt, Naeem.
Stefante, would you like to say anything? Thank you for being here. If you want to say anything. This is Stephon Clark's brother who came from Sacramento, California to stand with the family.
I just want to say just a few words from my mother. She just sent her emotional support.
Thank you. He couldn't get the words out. He said that you remember his family went through this as well. We'll try to take a few of your questions.
Ben, I just want to clarify. Are you saying that you do not believe that this was an accident, that the officer intentionally and knowingly used her firearm and not the taser? You think this whole taser...
I don't want my words to be misconstrued. I don't know what's in her heart, but what I do know, she used excessive force because he didn't even need to be tased. When you look at those videos at Attorney Crump, go look at those videos of those white young men challenging, attacking, assaulting, and battering the police. And they did not shoot them. They didn't use tasers on them. And so why is it that they do this to black people? And when they over-police us, when they use the most force, it has deadly consequences for us and our children.
Ben, I have a question for Katie or for Dan, if they want to answer this, but we're going to see her in court on a Zoom link. If you got a chance to talk to her, what would you want to say to her?
I don't even know what I would say to her.
Is there anything you want to hear from her?
Okay.
Ben, this is a very sensitive time for Minneapolis, for the state, for the country. People are coming in around the country, around the world for the Chauvin trial. They're coming here earlier now because what happened to your son. I'm very sorry.
Right. This was the very worst time something like this could happen.
I tell them thank you for coming and standing up and supporting my family and other families.
And we ask everybody to obey the law.
Is there any way that you would, is there any way to take the second-degree manslaughter and have it challenged and given to the Minnesota Attorney General to have more strict charges possibly?
I'm going to have Attorney Storms answer that question.
So, yeah, the charges can be amended at any time, and it doesn't take the Attorney General to do that. Mr. Orput could do that as well. So, everything is in the early stages. But what should be clear to everybody is that they acted swiftly because it was so obvious that what happened was an unlawful killing. And as the evidence comes out, they'll refine what those charges ultimately are.
They can do that.
Absolutely.
Can they get pressure from you or from the Attorney General to do that?
They can, and I assume will, get pressure from many different sources.
Do you think they'll be increased to third degree?
We are in the initial stages of our investigation as well. Believe me, they get way more access to the information than we did. We've only gotten a very little bit. So we'll be prepared to talk about what we think should happen when we're fully educated. But we can tell you what did happen was an intentional, deliberate act of force that began with an intentional pretextual stop and ended with an intentional pulling of a trigger.
Mr. Trump, can I ask you a question? You are saying that you see progress, that there's criminal charges here in many cases there have not been, but then you're also saying the charges
It's a long journey to justice, and I want to thank the young people and the activists and the people who are protesting the injustices that they see, because it is making a difference in America. We have to remember, not so long ago, they weren't charging any police officer for killing a black person. So we're making progress in America. Are we at the point where we can say it's equality? Oh, we're a long way from that. But we're making progress. I think Attorney Storm said it best when he compared the analogy of Officer Noah and what everybody always believed in our community. If a black officer shoot a white person, oh, they're going to be charged. And they're going to be charged to the fullest that they can be charged to. And so that presented us with empirical evidence based on what we saw in that case. The question has always remained in America: can minorities get the same equal justice under the law when white police kill us? We'll take a few more and then we'll. Yeah, with Philonis and them, interaction. How was it with George Floyd's brothers?
It was very emotional. George Floyd's sister or girlfriend actually taught my son at Edison, and she remembered him playing basketball, and she remembered him just being that smiley, goofy kid, and it was just very emotional, and it was so sad that we had to meet that way and that our families connected in that way.
Okay, one last question.
So we know that Dante was a father. Is there anything else that you want people to know about Dante specifically to remember him by? I know we're seeing a lot of maybe things about the things that happened to him, but just what are some of the things that we should know about him and remember him by?
Talk about who your child was, who Dante was. Talk about who Dante was.
Do you want to?
His sister will talk about her brother, Dante. This is his little sister, Destiny. Just tell him who your brother was. Take your time.
My brother, he was the most delightful person I've ever met. Like, he was everything. Everything. His smile, his jokes, his everything about him. And she took that from us. And I'm very disappointed. Very disappointed.
Anybody else want?
How can people help the family during this difficult time?
Okay. I have an uncle who wants to say something. The family has started a GoFundMe account, and people want to help. It's and I have Adna give it to.
GoFundMe.com/Dante Wright.
And is the funeral date set?
It's going to be on Thursday at 12 noon Central Standard Time at this church. Reverend Al Sharpton will deliver the eulogy. I'm sorry? Destiny? You want to say what your whole name is?
My name is Destiny Wright.
How old are you?
I'm 14 years old. Yes.
Yes,
All right. So, two things with me. First one, like, it's kind of like to double back the question, you know. I know y'all got a lot of questions. But like on another aspect, if y'all really looked at the video and then y'all asked the family, well, what you think should happen? But if you really look at the video, do you really think that that other big guy behind my nephew needed help when he had handcuffs hanging in his hand for at least 5 seconds? So I think that's what y'all should ask. When y'all ask like how we feel, how she should get done, do y'all really think that first guy needed help? It would have been prevented from all that. He had handcuffs. If he really wanted to take him, whatever it was, he could have did that. First thing, and that's the other thing I say about my nephew, hey, he knew, he gonna tell you the truth, and he knew who to respect. I never seen, and we talked about that. Anytime I come out here to visit, I never seen the bad mad side. I always seen him happy. He happy to see me. We up early talking, late night talking. I didn't see what people gonna try to make it out to be. We ain't, you know, so he knew how to conduct himself. But go back to that first thing. Y'all asking a question that's obvious. Y'all saying, what do you think she should have? Did you see the video? My nephew, 135, he a big old guy. He had control of it. My nephew was cooperating. So, you know, with that, I mean.
Okay. What's your name? Okay, you want to tell him?
Oh, Calvin.
Calvin
Walls.
Calvin Walls. And one more uncle wants to say something. Uncle Bobby.
My nephew.
Now, this is Aubrey's older brother. And state your name.
Bobby McGee. My nephew, my whole family for that matter, we are so close. We are all in different parts of the country, but no matter what the situation, we always get together. This is not the situation we like to get together for. We're usually having get-togethers, cookouts. I mean, they just was at my house for my birthday, and we just experienced a great time together. And for me to know that's the last time I saw my nephew, I feel like, you know, you guys have taken away many other birthdays that we won't get to celebrate together. Not you, but this officer. So for that, charge her. Charge her to the max sentence. Hold her accountable to whatever it is that the state thinks she should be held accountable for, but let it be the max. We can't have them back, so why should she get back in her life? That's all I got.
This is his father, Aubrey Wright.
I have to say something. You know, we're here to talk about my son. My son was a good young man. He was a young man in the making. We were building my son up to be somebody. He was gonna be somebody. He was a good kid. I'm very hurt. I don't really talk much. It's taking a lot for me to talk right now in front of the crowds and stuff, but my son was very much loved. We loved him a lot. And the way he was killed, he did not deserve that. So I just wanted to say that. I felt like I had to just tell you guys what's going on is unfair. These young black men being killed. Can you blame my son or anyone else from being scared of the police? We teaching our kids how to act around police. I just had to say something. I thank you for listening.
It's his son. What you mean? Everything.
Thank you all.
Twelve to 15-year-olds' new Pfizer data shows their vaccine is 100% effective against symptomatic disease with no major safety issues. Now, trials for 6-month-olds to 11-year-olds are now underway, but any vaccine approval for that group would be 2022 at the earliest. All right, shots of a very different kind will be served up at First Ave next week. A vaccination clinic is happening at the Famous Music Club. That'll be on Monday. Anybody 16 years and older can sign up to receive a Pfizer shot. This event is being hosted by the Twin Cities Music Community Trust. The vaccination opportunity initially opened up to local music artists and industry staff last week, and now the trust is spreading the wealth. Appointments have to be made, though, by noon on Saturday.